Hey guys, hello. Okay, hello everybody. Hello to everyone that's coming into this chat. Good afternoon. Good afternoon. Today has been extremely different, and I just want to, I want to use woosah for a second because, guys, there's movement. There's movement in the YSL case. Finally, can we all woosah for a second? Can we say finally? Can we say finally? Finally, guys, finally. Finally, right? Finally. I'm going to give you guys some of the feelings that has happened. I'm going to share some stuff that's not on the camera. I'm going to go from the beginning. And I told you, did I not tell y'all when I went and did my investigation, my nosiness, I told you Judge Whitaker is a stickler for punctuality. I told you that from what I've heard from the people who work her courtroom, she does not play. She's a person that comes, she's on time every time. She don't believe in tardiness. She don't believe in things not done in decency and in order. And she has proved it to me today. And I'm so glad that I did take the time to go and find out a little bit about how she handles her courtroom. And guys, you heard her. What is some of you guys' opinion about how she laid everything out? She laid the rules out. She laid everything out so folks will know what to expect from her and what she expects from them. And it's like a courtroom. And I'm not trying to bash anybody at all, y'all. I'm not trying to bash anybody, but she's operating a courtroom like I've experienced. There's some judges in the courtroom that are super strict. And I tell you some of them who are super strict. One is Judge Adams. She's super strict. She's so strict that you can't even put your arms in a chair. You got to sit up. You can't let the door swing. She's Judge Adam, but the Judge Adam don't come on in time. She's late. You know what I mean? And then you have Judge Cox, and he's strict too. And I don't believe she's as strict as some of the others on certain things, but as far as running the courtroom like a smooth machine, Judge Whitaker is that person. As long as you follow the rules and give her, and she's by the law, y'all. She's by the law. What the law says is what she sticks with. Okay. If you give an argument and you give her the law, she is going to rule in accordance to that law. Okay. But I'm going to share with you guys some stuff that I personally observed when I got to the court on today. The atmosphere was totally different. It was more of a disciplined, quiet type of environment. Okay. And I'm going to give you my personal experience, okay? Now, nobody can change what my personal experience is, okay? Because I'm going to be totally honest with y'all, okay? And it's not going to be about me, because somebody said to me today, because I was telling y'all, I was speaking with someone, and I told them, hey, I didn't get the kind of greeting that I normally get from the state, and like Sylvia, don't make it about you, because it's not about you. They're dealing with what the changes, because before they used to be able to run the other judge. Now they can't do that. So now it's like, don't take it personal. So I took it personal, y'all. I took it personal because I was like, I didn't get a hug, Miss Hilton. And she said, huh. Y'all, she said, huh. I said, oh, so it's a New York Philly thing. All right, I'm just telling the truth, y'all. Telling the truth. What happened to me today? Okay, I'm just gonna tell y'all the truth. My personal experience. That's it. That's all I can tell you. Okay. So nobody come at me and say, oh no, no, no. I'm telling you my personal experience. That's all I can do is tell you my personal experience. And I'm gonna leave it there. Now, through the eyes of Sylvia, my observation in today's court proceeding, and prior to me coming, when I first entered the hallway, when I came in, I looked down to my right and I saw Mr. Adams. He was like on a phone and he was standing and talking to somebody. And then I saw Mr. What's his name? Weinstein, not Weinstein, Mr. Harvey. Mr. Harvey was near the window, and Mr. Chard and Mr. Steele and another attorney who I did not know, who I did not recognize, were coming down the hallway towards me. And the demeanor and disposition of the defense attorney was pretty jovial, meaning a little bit pleasant and a little bit more, I'm not going to say happy, but not rigid, not structured, not not heavy. Okay, it was more light. I saw type of environment from them. So I went and I gave them all a greeting. They all hugged me. And Mr. Botts had told Mr. Steele, because Mr. Steele had went into the bathroom, because Mr. Steele brushes his teeth several times a day. He was going to the bathroom to brush his teeth, because he brushes his teeth many times a day, right? So Mr. Botts came, and I said Mr. Botts, and me and Mr. Botts embrace each other. And so Mr. Steele was walking by, and Mr. Botts said, hey, don't forget about Miss Sylvia. So Mr. Steele hugged me, and I embraced all of them. And before we knew it, it was time for us to go inside the courtroom because the judge was already on the bench. Right? So we get inside, and I didn't even have my camera set up yet, because now today I did not have a chance to even do my own camera thing, because court had already started. You know what I'm saying? Court had already started. While I was sitting in there, I realized my streaming was having some buffering, and I had looked on my laptop and I said, oh my God. So I had to run out the courtroom while the judge had asked everyone to do an introduction and to, tell them who they are, who the client was, and things like that. So I had to rush out of the courtroom, and I had to go into the media room to try to get my streaming together, right? Because it's been a while, and I had to do some maneuvering around. Hold on a second. Hold on, y'all. Hold on. Okay, I'm sorry, guys. What was I at? I was telling y'all something. Where were I at? Somebody, sorry about that. Where was I at? I don't want to repeat myself. Oh, I was telling you that I had to go because my system was buffering, so I had to leave while she was asking. Yeah, I had to go to the media room. Thank you, Miss Kayla. Kalia. I had to go to the media room to get my system up because it was buffering, right? So by the time I got back, she had gotten up to the part where they were giving them certain things that were giving her certain things that was happening, what motion they had filed for their clients and stuff like that, right? So the deputies, it was a different feel in the whole room, guys. When I did, because I even typed to you guys, I felt kind of nervous because the deputies, some of them was the same people and some of them was different, right? And the feeling, it was like they had notebooks and they were taking notes. I'm talking about the deputies. They were sitting down taking notes, and the environment was so I didn't feel the bullying that I used to feel in there. It was not a bullying type of thing in that courtroom. It was more like the first day of school, guys, and the teachers up in the front, and all the classmates new to each other, and everybody's trying to learn each other. Everybody's taking notes. Everybody's focused and taking care of their business and that type of thing. That's the kind of environment it felt like inside that courtroom today. It was really today was really what I expect the courtroom to be like. Okay. And you saw the rules that was laid down. But let me tell y'all something. Somebody was tattletaling, and the tattletaling came from the deputies. They tattletale. They talked about the earphone, the earpod, and the music listening, the clothing. The clothing definitely came from the uh, um, the deputies, because do you remember last week and I was telling you guys that the families, how they would bring the clothing in, and they had like bags of clothing, heavy clothing. They had to carry the stuff out, right? And I know definitely that they have had issues with so much clothing that was being brought in by the family members. And I remember that. And also the snacking, they squeal on that. People eating, like she said, she don't mind them eating, like when they have no lunch and they can, you know, do it there. But during the proceedings and during somebody being on the stand, she will not allow them to snack anymore. Okay, you could drink water, but you cannot do all that snacking and stuff that they've been doing in the courtroom. How slack the courtroom was. The thing that really got me, y'all, was the conversation about, her comment about how they treating one another with respect. If y'all notice that the camera was kind of on DA Love. Did y'all notice that? Did you notice that they put the camera on her when she was talking about the attitude part? Yeah. Yeah. So how I feel about the first day, what's my feeling about the first day? I think we're gonna get a lot done. And did you hear the time that she said? From 8:45 to 6 o'clock. That's gonna be a problem for some of the jurors, because some of them have kids to pick up, and there were some promises made to them that they will be out by 5. So I think she's gonna probably adjust the 6 o'clock thing, because once the jurors come in, they're gonna know that there was some promises made to them. So I think that's gonna be adjusted as well. Okay. Because there's jurors who have children to pick up, and so she's going to have that adjustment. And I know for a fact, because she hadn't sat down with the jurors to talk to the jurors yet. Okay. There's some motions that was submitted today, and I'm going to send the motion to my young lady so she could come up and read them. Okay. There's going to be motions coming in left and right. Left and right. There's a lot of motions that Mr. Steele is going to continue to submit. And hey guys, did y'all notice what she said? You notice how she said about having some sort of plea agreement, some coming down to having a conversation to each other, talk to each other, because she really wants this thing over with. Y'all know that, right? She wants this over with. She does not want to keep carrying this case till Jesus come. She does not going to keep going around and around with this case. She wants this case to be handled. She wants them to come to some sort of agreement, and so we don't have to prolong this whole process of this trial, right? So in the middle of the case, they can come up with some sort of agreement, and it could end the whole case right away. And I think she would welcome something like that they can come up with some sort of agreement. Like, for example, they say, hey, we'll take a plea of the lower charges, right? And do some time served. I think some of them would take that. What do you think? Wouldn't you think that? Especially some that having some like heavy stuff against them. For example, let's say Jeffrey has I'm just giving an example, yeah. I'm just giving a small example here, right? Not like a lesser charge, no plea. Okay. I'm just asking. I'm just asking. Y'all don't shoot me, because I'm just asking. I was just gonna make an example. Y'all like no plea deal, definitely. Okay. I was just saying, just think. Okay, all right, I won't. Okay, suppose, there was some that had gun charges, and okay, never mind. I was just asking. Hold on a second. Let me see if they submitted this stuff for me. Hold on a second. You said Quay and Yak should. Jiggy said, Quay, you know what, Jiggy? I need you to come in here. You're the only one brave enough to give a difference of opinion from everybody else. Ziggy, hit that link for me. I just need to hear from you for a second while I get these motion. Ziggy, hit the thing. Oh, I want to tell you guys, I am going to have Attorney Gardner as an interview. He's going to interview with me as well, guys. Attorney Gardner, he is going to come in. You guys know who he is, right? the gentleman that dresses really, really nice at court. He sits in the back next to Mr. Harvey. He's the other attorney for Mr. Nichols. He's going to be my next guest. Cuff Boys! They go Cuff Boys, y'all. Hey, Cuff Boy. So he is going to be my next interview. He's going to be my next interview. So guys, what do you think? What is your opinion of the first day with Judge Whitaker? What do you think? How do you feel? Do you feel the same way I feel, that this case is going to move right along and things are going to be totally different? And you see, she asked about the witness list. She wants that witness list to be cut down. She wants some definite structure to that. She wants the structure. She's not playing with them. And she's a stickler for structure. She's a stickler for being on time and meeting deadlines. Because I told you, based on from my investigation and my nosiness of going to find out about him, you're not gonna come? Y'all too scared to hit the link? What's going on? Y'all afraid to hit the link? Y'all afraid to hit the link, huh? Okay, I got the first motion that's still put in a motion to remove Love and Miss Hilton. And you guys, I'm telling y'all, they watching these channels like a hawk. And I think you guys caused me not to have a hug today, because you guys have been so mean in this chat. Hey, AJ.
What's happening?
Thank you for being brave for coming up to have a conversation with me, because everybody is scared.
I was waiting on everybody else to pop up, man.
They're scared. They're afraid to come on up in here because well, what do you think? What is your first day of school opinion of what went on today?
It's a brand new day. And the way you were describing how the courtroom feels, it sounds like the cloud has been lifted. You know, they can actually do some work now without having to police the other guy now. You know what I'm saying? They had to break down the law and fight against him. Now they can have court now. It can be a fair trial. And she made it very clear, because I thought she was talking to Love indirectly the whole time, that this evidence games you playing, these witness list games you've been playing. I said I've been watching, and that ain't gonna fly no more. She got to come with it. All this introducing new stuff, and once she get abreast to it, I'm talking about Judge
Whitaker.
She gonna narrow everything down, man. It's my belief. I think she probably call the trial if Love start playing dirty again. If she think she can play those type of games that she did with the other guy, talking back to him after she ruled, making him change his mind. Ain't none of that going no more.
Hey, Renee. Hey, Emmanuel. Renee, what's your opinion? What do you think of first day of school? I'm going to call it first day of school, y'all. I'm going to call it first day of school.
Well, you mentioned school, and I just finished with finals. But today's class, I say, was amazing. It was a breath of fresh air. I would say that it was very comforting to see the courtroom etiquette. Your organization is as only strong as your administration leading it. And I think with her taking charge and being the judge assigned to this case, we'll see the wheels of justice turn much faster. We'll see them turn with confidence, where we're not questioning, well, should that really have happened? I know one thing that Attorney Adams says a lot. You don't have to have a law degree to know when something just doesn't feel just. And I think her being a mediator, it seems like she's the middleman. She's not with the state. She's not with the prosecution, but she's going to hold both of them to the same account. And I agree with some of the things that she was throwing out there as saying, okay, we're not going to do this. We're not going to do that. those gripes, they came from the sheriffs. I totally agree. And it sounds like to me with the gripes that they have, if a person was out on bond, you wouldn't have to worry about their clothes. You wouldn't have to worry about them eating. So just their gripes from the Fulton County Sheriff's Department alone should warrant a bond.
But you know what, Renee, I agree with you on that, because one of the things that Mr. Matthew got up and said is because he allowed his client to listen to these, to case evidence and videos based on the discovery and things like that. So, and she's saying to him that, hey, you got to find another way to do it. You can't do it during the time of while the trial is going on. So now he has another like open avenue for him to say, hey, I'm not able to go over discovery with my client because I'm not able to see him during such and such a time because we're in court. And if he was home, I would be able to have him to listen to this, because in the jail, he's not allowed to listen to these things. He's not allowed to have the discovery with him. And so I need him to be able to be out to hear or listen to these things. So that might be another avenue.
Yeah. And further, to piggyback off of that, what you just said, Your Honor, there is no reason why I should have to go over discovery and allow him to hear these recordings. If they had been previously disclosed, we wouldn't be going through this. I think if they are timely disclosed at that point, there's no need for my client to listen to these recordings because we've had them timely disclosed to us. We've had time to review them. So this burden that appears to be, on our part, it's a burden that has been shifted upon us because of the lack of discovery and also adhering to the orders that have been already put in place saying have discovery. This stuff, there is no reason why we should be going through discovery. And one thing that she said, which this trial was totally different for me, because we're taught in school any disputes or anything that we want to argue about as far as admissibility of evidence, that should be done on the front end, pre-trial, not during the trial, which because it slows it down. We see it. So we see the method to the madness. This stuff, motions in limine, is what you file when you want to either suppress something. When you want to suppress something, evidence, you file a motion in limine. Motion in limine, I've never heard of this stuff going on during a trial. That's why trials only last short periods, because all of the madness and the chaos, that's been worked out and it's been settled. And we should not be arguing over this point. We should not be taking this jury out of a box. I'm sorry. The prior court that had this case, they did a disservice to those jurors. And they should be paying them double.
Yeah.
Triple.
Okay, hold on a second. My two people. Victoria Johnson says, who was the new additional attorney for Thug? That was the gentleman that I was telling you that was walking down the hallway with Steele and Max. He is just like, I don't know if he's actually an intern, but he's like, they're just temporarily like the others who have sat there. So it's not anybody that's actually part of the team yet. Not right now. And then John says, I think by the end of next week, state will have a motion for Whitaker to recuse herself. All right. Emmanuel, what is your thoughts?
I like this judge for the simple fact is that, of course, she's on time. And she's straight to the point, like she stated. Have your witnesses ready, and don't be late on them. One witness after the next. I like her. She's on point.
And you know what I like also? Remember the part when they were talking about having to get the list, and she said, "Oh, I can go get that myself because I can get that from the court reporter, and then we can match it up.
Yeah.
So she's willing to dig in and do the work too.
Right, right. She sounds like she's a more independent judge, and she doesn't mind doing uh extra work.
Okay. Shell B.
Hey,
Hey,
how you guys doing?
we're
I
good.
good. I was able to get on this morning and hear the hearing or whatever we was doing at 11:30. I don't know what you call it. But I was in the courtroom with you in the chat, but I didn't get to hear what your thoughts was about it. So I'm not sure if what I have to say was already said or not. But I like this new judge. I felt like she was being she's about her business. She's not playing with her time, our time, the jeweler's time, nobody's time. So I love and respect that. I definitely feel like she runs like a tight ship. You know, she is going by the letters of the law, how a trial is supposed to be ran, you know, not how we've been accustomed to seeing in the past 8 months or whatnot. So I definitely appreciate that. Everybody was on their best behavior today. So it's a matter of time before them true selves show up, and I'm going to be here for it, you know, because I would like to see how she's going to handle it and handle them in that. I feel, you know, I don't feel sad for Love and Hilton, but they better get their stuff together. You know, they better call in some extra reinforcements. You know, they better have these motions filed on time. They better, you know, everything that she requested, they better have it, you know, together in order, because it doesn't seem like she's going to give much grace in leniency. She might give them a little bit, but she's not going to Glanville them at all and act like the abomination of her order has not been done. And just dismiss their, you know, disrespect or them just ignoring whatever that she says. So I'm interested in seeing it. I do want a little bit of clarity though, because I heard Tuesday she wants all the motions filed, right?
Mm-hmm.
But she doesn't want nobody's coming back to court until that following Tuesday. Is that correct?
Following Tuesday, yes. But they have
Okay.
deadlines for certain things, because she says if they have like anything, any evidence they want her to hear, like recordings or anything like that, so she could be abreast and hear it ahead of time before they start these motions. But she wants those motions to put in so she can have time to read it, review it, and all that. But you see who her staff attorney is up in the front, the lady that sat
The
up,
lady. Mm-hmm.
yeah, the one that was sat where
not next to the
Wesley used to sit. You see where Wesley used to sit?
Yeah. The one that was like right in front of her. The one, not the court reporter that's leaving. I
Not
think
her.
that
The one that's on the left. Is that her right? I think it's her
Mhm.
right. And then the black lady is her legal
she like the secretary of the court, kind of like.
yeah, but she's the one that all the emails has to go to when they're putting things together. She just don't want. She even told them, even if you're putting something electronic, make sure you send it to us so we'll have a copy, because there's time that they may not get what's being put into the system through Odyssey. So
Yeah, she said, "Don't rely on Odyssey notifying me. You need to
yeah.
notify me and let me know."
Yeah.
Yeah, I'm here for it. I'm here for the new judge, and I'm in great expectations, like she is for those filings. I'm in great expectations to see how everybody's going to handle themselves moving forward. I do think that she's looking for an out. Anyway, she said, "Send me a plea deal." Honey,
I said the same thing. I think she would rather for them to do it without her making any decision. She wants them to get together, communicate with each other, come up with some sort of plan, and I'll review it type of thing.
Yeah.
She'd rather for them to try to work it out.
She said, "I invite it, I encourage it." And so I know when she said it, you commented in the chat and said, "Still is smiling." So that was music to his ears. I do think another thing that I think about it, I think that maybe the tone of Steele's, not the tone, but maybe like the extra banter or sarcasm or the stuff that we find quite entertaining in Steele's motions might change a tad bit, I think, because I think he was definitely writing to appeal appellate courts and stuff like that, more so than to like get Glanville to like go with, you know, his side. So I think we might see a different tone in the way that Steele writes his motions towards this court versus the last court, in my opinion.
Absolutely. I agree with you. AJ, you have something you want to add to that? What Shell was just saying?
Oh no, I was just gonna piggyback off what you were saying about how the new judge is just on point. She's getting all the ducks in a row. And I thought she was flat out lying when she said she wasn't paying attention, because from what she was saying, you could tell she was paying attention.
But I think most of it, okay, there is a particular deputy that is in the courtroom that used to be her deputy.
Okay. So she's abreast.
And I know for a fact information has been being related to her from this particular deputy, because this deputy had been with her for a while until the YSL case came, and that deputy was moved to this courtroom. So now they're back together again. So a lot of stuff that was going on in the courtroom, that deputy has relayed that information to her.
Definitely. And you could tell from what she was saying, the way she was laying down the law to like I said, I think she was speaking to the state. You know, like basically she don't want to pull she don't want to call the trial. She want them to do it. So just get your ducks in a row and let's streamline this, man. We're not gonna be sitting here going through 16 hours of non-important tapes. We're not gonna sit here and pull up old IGs that ain't got nothing to do with nothing. Like all this extra evidence. So I think Love gonna have to go through her witness list and find out who's really important. Cause I don't think we need to see no more crime scene texts up on the stand no more. So she gonna get it to go.
Okay, I wanted to tell everybody that the courtroom that we are in is the same courtroom that Judge Glanville was having. It's the biggest courtroom in that court. The reason they use that one is because it's already set up, and it's set up for the 6th defendant and their families, because their family comes in. They weren't in there today, but they wanted to keep it the same way, the same setting. And also this live streaming wiring is already done in that room, so they kept it in there.
I got a question real quick, Sylvia. Who was Turtleneck, and why was they taking a picture of you?
You don't know who Turtleneck is?
Nah, I don't know. No drama.
We all want to know Turtleneck.
I don't either.
Y'all don't know who Turtleneck is?
I have no clue.
The same person that, come on now, y'all. The black dress.
We talking
the
about
one that got a case with?
He's the reason why I got a case, because he's talked to the other person that gave me the case.
Oh, never mind. I thought it was something else, man. I don't want to talk about it.
Oh, okay. Okay.
That was before my time, but I'm gonna leave it alone.
He a fan. But anyway, how was watching Love and them move around? How was they today? What was different in them?
They were a little bit like distance from me. They weren't warm. They were very I felt cold. And I guess I was taking it personal, but then I was like, you guys been really dogging them in my chat, so they've probably been watching, and y'all just like be going in. I'll be trying to like, y'all please be nice. Don't say that. Don't do that.
It's the truth. And if you can't take the truth, then go to another chat then. But
they set you free. Don't worry about them, Miss Sylvia. We got your back.
But I just felt a little bit like shunned, because I was like, I didn't get a hug.
I don't think it was you. I think they know the jig is up. I don't think it necessarily had to do anything with you. I think they know they have to fly right. So I wouldn't take it personal.
You know what I'm saying? You doing your job, man. Keep doing your job. You ain't got no hater. You ain't doing it good enough.
Hey, Mitchell, you here for your brother, huh?
Yes. Actually, I don't know where he's at. And
I thought that was him. I was finna say
no,
something.
That's not past. That's past the brother, twin brother. Remember, he has a twin.
Yes. Yeah, actually, I just came in not too long ago. We got indictments all up and down the East Coast. I was with some attorneys who are doing indictments today here in Baltimore City. It's cooking. But what I like about this case is cooking to be over. I like what the young lady just said. Steele's motions is going to very much calm down. His way of writing after reviewing all his motions was nothing but preparatorial means for appeal. The appeal courts, they don't want this case in their lap. If they get this case in their lap, it's going to be automatically, overturned. They're just going to automatically overturn. There's so many disculpatory rules and violations that have been constitutionally. The appeals court's job is to make sure that it doesn't leave the state of Atlanta without a right remedy to not allow the defendants to financially sue the state. So that's why I like what she said. Hey, look, come up with a plea deal. See if these people going to, because they're putting pressure on her to say, hey, look, if it comes up here, we more than likely going to dismiss this. These defendants going to have a right to sue. Because there's so much conduct. So they pressured her, I guarantee you, to say, hey, run a plea deal by them. See if someone going to take a plea deal. We can do time served. If we can get time served on the books right now, then we run a risk of not being sued. If we can't get a time served plea deal, then we're going to continue to have to drag this out. That new judge she's going to be caught in the crossfire because that's years and years of pleadings in which she and that clerk is going to have to do. And that's just going to put everybody way back. The jury is going to be, less tired. The jury have already found about this case, heard more about it. I saw this stuff on a bus stop. You didn't even have to have a phone. I'm in my state of Maryland, and it's Free Thug and Glanville faces posted everywhere. So everywhere that these jury go, they're going to find out, the good, the bad, and the ugly. And when you do a case like this, where not only one judge, but two judges recuse themselves, that sends a message not only to the state of Georgia, it sends a message to every state as well as outside of the United States, that, hey, guess what? We got one individual state in prosecutorial misconduct who just can't get it right. And people are laughing at us. So they run the risk of now playing cleanup. I'm going to say by December, these boys coming home. They're definitely going to come home.
All right. Thank you, Mr. Mitchell. All right. Jake.
Can I ask a question real quick, Ms. Sylvia? Just about the officers that you had mentioned that one of the deputies is the same, that they have a relationship, because I noticed.
No, I didn't say they have a relationship. I said they work for her.
Oh, okay. They had, history, not like that.
I just want to clarify because folks will be like, "Oh, Miss Sylvia said they had a relationship." No, Sylvia didn't say that.
No, that's not. I didn't mean like in any kind of improper way. They had, just like she's worked with, Smiley before or whomever, everyone in her counters. Anyways, back to the point is I was wondering, because she had all these housekeeping rules that she didn't even fully understand herself, like the clothing thing, the headset thing, and stuff like that. So my question, I wrote my little questions down for you. So one of my questions was, are the bailiffs or deputies, I'm not sure what you guys really refer them to. In Cali, they're called sheriffs. But the officers of the court that control the court, are they different? Are they all different from Glanville's, or are they the same? I know one of them.
Each judge have their own set of deputies. Each judge.
Okay. But there is one that is common from both courtrooms.
No, they just happen because this one is a larger case. So some of those that was on there before is still downstairs.
So there are some of the same faces from when.
you don't see, I don't see the ones that's normally there. No, I don't see, except one person that was at the door today.
Okay.
Normally the other ones they're usually down there. I didn't see any of them.
Okay. That's my question. Go ahead. I'm done.
All right, JL.
Good afternoon.
Good afternoon.
I'm just stopping in. I just want to say that I think I knew it was going to continue. I knew they were going to give us a little bit today. I really like that she set the rules up front, though. I did appreciate that fact. I did see a particular person, and I don't want to point others out because I kind of seen a look that was given towards the camera your way today. And I didn't know if that was the law and crime camera or your camera.
You talking about for love? I saw that look too.
Oh, it was bad. It was a really nasty look. But I
seen
think
that look too. It was unspeakable to me, and I'm like, what?
Yeah, really caught me off guard. So
well, we gotta take a look at that look. So, guys, I know people don't know what you're talking about. So go ahead, Jay, pull it up, please.
So I just had, looked at that, and, I was just looking into other things through the misconduct that obviously we have seen throughout the case. Now, I just have a question, and maybe this has been answered to you, Ms. Sylvia, through the attorneys, and I may have missed it. Why wouldn't the malice prosecution ever would be considered? Or how about the Georgia Supreme Court adopted the rule to hold prosecutors accountable for misconduct? So why wouldn't that apply?
Well, you got to realize Steele just did a motion recently that has not been addressed yet, and maybe the judge will address that.
Okay, so is that still a thing by you guys in Georgia? I know it was temporary. Is that still in place?
I have not a clue, but I don't know.
Okay.
Would you like me to answer that?
Sure. You're the man with the knowledge.
Yes. So rules of conduct are handed and affiliated with the upper courts. So the lower court will have they barely wouldn't touch it. That's what they're leaving Steels to do, to file his motion. Steels is going to file that motion not with the lower court. He knows that he and any other defendant, they have to file that with the upper court, so that way they can say, hey, guess what? These have been the rules of, attorney, misconduct, which needs to be addressed, because if they're not addressed, then we continue to run, back at this, gravy train at any given time during the trial, if whatever the appellate court for in that individual states, because they're basically the same in all, say that can make or break a case too. So the case could be going on, tomorrow for 30 days, and appellate court make a hearing, and then everything is placed on hold and say, hey, guess what? The judges, feel that, Miss Love or Miss Hilton or the prosecutor office violated a constitutional means so egregious that we got to shut it down. And which, again, there's been several. I'm a very good stewardess and expert in Constitution violations, and I see 4 at max. I just don't understand how they're going to get away with. Again, I fundamentally believe they're going to take these plea deals. Here's the reason why I think it's going to go on, though. Steele has a thing for justice. Steele has a thing for showing that, hey, guess what? If he has to continue to go before this court or any court for the remainder that he wants to practice, he wants to do it with the respect intact. And he's not going to let none of this go. They're going to get so bummed out by Steele and his motions that they got to do something right away.
All right. Thank you. Thank you
I
so
have
much.
a quick question, Sylvia.
Go ahead. Go ahead.
Oh, my bad.
No, go ahead, AJ. I was telling you, go ahead.
How
Okay, sorry about that. So
No,
that
I'm
was
saying AJ.
AJ. Oh,
AJ. JL afterwards. Y'all with the J's.
oh, but no, how can Castile filed the motion about striking Woody's testimony, right? And if memory serves me correct, after the ex parte, he wasn't supposed to be talking anymore on the stand, but they continued. So if Woody's testimony is struck, how is that gonna play out with the jury? I mean, you can't unsee somebody. You see what I'm saying?
That's when the jury motion against the jury is gonna come about. If that goes on, then they're gonna do the to do that jury polling and all that kind of stuff, that what we talked about before.
Cool. Thank you.
JL.
so that actually answered my question. I was going to ask, what about the jury? Since the jury has been out several weeks and she sounds like the judge is going to keep them out and there's going to be a lot of argument to come. The deadline Tuesday, I feel like it's going to be a lot of motions dropping left and right, but it's them, if you ask them, it stopped at what, day 102? Was it 102?
100. Yeah, I think it's 100, right? I don't know. I'm
So
counting. I'm stopped counting.
So somewhere between, we just say day 100 to day 102. Now, if you would honestly and ask every single juror independently, what did witness number 3 say on day 7? They're not even going to know what happened on day 90.
Yeah.
So let's bring logic into this. Beside all this ethical, I'm professional duty and all of that, in the mind of the juror, that should be the main focus right there. Because those jurors are not going to be able to recall anything from the first day all the way up until then. And then how do you expect all these weeks to go by and you come back and you say, well, the world's gone crazy about this testimony, but now I need you to unhear this. And I need to take your notes. And whatever video you've seen in reference, whatever you read, you have to disregard that. So I'm saying, what then at that point? Or what will happen if a juror comes forward and says, I don't think I can complete this job because I can't tell you what's occurred 95 days prior? That's my question.
Well, the jury is going to, the defendant's attorneys are going to put in a motion because the jury has been tainted. So that's enough for the judge right now that's on the case to weigh in on, because they have been tainted in a major factor, to the point to where as though they would not be able to, even if she really went on with this case, to be able to render a fair and just verdict. They hear everything. The moment that they heard that Glanville have been recused, and he was recused by Steels, they already made their mind up. So right now, it's like, again, Ms. Sylvia said, and then in my practice of absolutely knowing, this jury that already is in place is tainted. So you either scrap it, take a plea deal, time serve, move on, state if y'all want to hear it, you continue to hear it. We can't oblige, but I'm letting you know, if we do oblige this, the defendant's attorneys and the defendants do have a right to use each and everything that has been, filed, said, whatever. I don't think this judge wants to play a game with jury because she knows it's been tainted. That's why she's there in the seat, because the case has been tainted.
You know, the other thing I want to say, if you notice the time frame she is given, the jury doesn't come back until August 5th. So there's a lot of things that's going to happen prior to the jury come back. So you don't even know if the jury's ever is going to come back based on what happens. Motions.
So with an August 5th due date for the jury, what's that real time total? That's like almost a month out, right? A month off? Ain't no way you could, no person, one of those 12 had consumed something. So I don't think it's going to be, I think they're going to play dumb, the jury, I mean, and they're going to follow the judge's lead. If she going to end it or the state going to end it, but.
I think she's going to weigh out everything because she told them all, make sure y'all put your motions in, you know? So I think there's a lot of light that's going to be shed to her, and she's going to take her time going through every single document and figuring out what's my greatest or best strategy to get through this case if we're going to get through it. Because remember, she did say if. Certain things.
That was an important word. She said if. And I heard it. It was loud. So I was like, yo, she ain't trying to be there.
But that's the main problem. That sentence right there is a problem sentence, whether anybody looks at it any other way. When she said she's going to take her time on this and call the jury out for another week or have to go further, that is adding on to the time that has already lapsed.
Right. But the reason she's doing it is because she no longer wants the interruptions that the other guy was having in between time. She wants everybody to get it done now. So when I call this jury in, we streamlining this.
No, understood. But you have to look at it from the mind of the juror. If you're already out a month, you're looking, maybe 4, 6 weeks, 8 weeks, 2 months, you come back. That's way further out to bring that person back to day one.
Okay.
You know what I was going to say?
Go ahead.
What I was going to say, imagine if this judge had this case in the beginning. Imagine if this judge had this case in the beginning. I'm pretty sure this case would have been done over fast.
She said that.
Huh?
She said that if she had the case in the beginning, we wouldn't be where we are now. She said that.
Yeah. This case would have been done.
But y'all know the other guy, he let a lot of stuff in that otherwise wouldn't have been allowed.
Okay, guys, I'm gonna go ahead and play some stuff, and because there are some people who don't know what we're talking about. They didn't get a chance to watch it earlier, so we're gonna take our time going through some of these things that the judge was saying. Okay, all right. So let me go ahead on and guys, mute yourself so y'all don't interrupt the flow.
Like moving forward. I know there are already a couple of weeks.
Okay, hold on. Okay, sorry about that. Look at Miss Westmoreland hair. I like her hair, y'all.
I'm not seeing her on the screen.
Oh, Your Honor, I'm here.
Okay, are you just not on video with us?
Right, but I'm here.
Okay, all right, well.
You sound terrible, don't you?
Good to have you. Hope you feel better if you might be sick as well, I think. Okay. Good morning. Okay, that sounds fine. All right, so a couple of things that we need to try to figure out from the outset. What is pending that I need to make a ruling on? And what our schedule is going to be like moving forward. I know there are already a couple of weeks that the jury has been sort of told you'll be excused for this week, so I will honor that. But I need for us to try to be efficient with the jury's time. So whatever we all need to get sorted out in the interim before we bring them back, as much as we can do, I'd like to do that so that we can minimize the times when they're here, but we have to send them to the jury room to figure out things that we could have figured out before. And I know sometimes that is going to be unavoidable, but to the extent we can avoid it, I'd like for us to talk to each other beforehand, give each other a heads up about what is going to be coming in or what we think might be an issue, and deal with it without wasting the jury's time, basically. So Mr. Steele, on behalf of Mr. Williams, sent me yesterday a list of what he believes to be pending motions that still need a ruling. And I think I have one that I know of from Mr. Huey, and I'm just going to kind of hear from each party as to what, as the state as well, as to what y'all believe is pending that we need to get heard. And since I've already got Mr. Williams' motions written down, I'm just going to make sure, Mr. Steele, that I've got all of the ones that you believe to be pending. So I saw in your email a July 8th and a July 9th motion to recuse both Judge Glanville and Judge Krause, which I'm obviously, we're not going to do anything substantive here today. I'm just going to make sure I know what y'all believe to be pending. A July 10th motion entitled for a fair trial that is essentially to find out about whether there have been any other ex partes. A July 1st motion that's kind of a proffer about something that happened with a jail call, evidence that's already been taken care of. And I mean, I'll look back into that. But a July 18th motion to disqualify 2 of the prosecutors. A July 10th motion asking, I guess, prospectively for a fresh look maybe at 24-8-801. And then you had also provided an amended witness list and a notice of filing. Are there any other pending motions for Mr. Williams that I didn't include?
It's not a motion that filed. May I address that just for your education?
Sure.
Okay.
And are you going to file it? You're just giving me a preview, or?
I could file it.
Okay.
I'll do whatever the honorable court desires. So I just want to bring to the court's attention, to be, fair to the court. May I approach, Your Honor?
Yes. And it may be easiest to just hand it to Ms. Pursfield. And y'all, it's on my mind right now. Before we all leave here today, I want to make sure that my staff has cell numbers for everybody. Okay. All right.
So I've handed this honorable court's co-worker and the state 2 cases, PROPST versus Morgan, MORGAN, and it's 288 Georgia 862, 708 Southeast 2D 211. And if you look at page 2 of the copy of the case that I've handed to this honorable court and the state, on the left-hand side, on the bottom last paragraph, our highest court explained that another line of appellate decisions holds that if a party, the reason I raise that is, Your Honor may be aware but may not be, the Honorable Douglas Weinstein filed an initial motion to recuse Judge Glanville. He did that on June 12th of 2024 in the afternoon hours. Judge Glanville initially denied, he stopped proceedings and he denied that motion without referring it to another judge, and he made some findings of why he's denying it. On behalf of Mr. Williams, the Honorable, yes.
Was there a written order?
He did file a written order
June the 14th.
Okay.
2 days later,
All right.
and that was the Honorable Douglas Weinstein.
Okay.
The Honorable Keith Adams and I, on behalf of Mr. Williams, then filed a motion to recuse, but we didn't file ours until June 17th. It's Monday, June 17th.
Okay.
But the way I understand the case law is that once Attorney Weinstein filed that motion, which the Honorable Judge Krause eventually granted. Judge Krause, in a written order dated, I'm going to tell you, July 15, 2024, granted Mr. Williams as well as Mr. Kendrick. Mr. Weinstein represents Mr. Kendrick, both of the motions. So the way I understand the case law is everything that happened after the filing by Mr. Weinstein on June 12, 2024 is invalid.
Okay.
You do hear that, right?
So if you would do me a favor and put that in writing and file it as a motion, and then I will add that to our pending list.
Yes.
And I don't want to, I appreciate you letting me know. I don't want to get into substantive argument about anything today because we don't have the parties themselves here. This is basically just a sort of status. So if you will file something to that effect, then I'll have that added.
You see how structured she is? She does not want to do any kind of argument without the parties being there, which is a defendant. Okay.
To the list, but I appreciate that.
I'll file it
Thank you.
today. Can I add one other thing just for your knowledge? But
Sure.
if it's something that's more than a status, then I will withdraw it.
Yeah, and I mean, you can tell me, but I'm, not going to consider it. We're not going to argue it. But yes, absolutely. Go ahead.
Understood. I just want you to know that there was a witness testifying. That's why I thought it's important, which will potentially, if you determine it, require the jury to have their notes, if you require it taken away and then wiping out what they heard. I just want you to be aware of that.
Okay, I'm not sure if I follow what you're saying now.
So there was a witness testifying. His name is Mr. Copeland.
Yeah.
After Judge Glanville denied that motion, the
Okay.
jury heard from a witness on the afternoon of June 12th, June 13th, June 14th, June 17th. So I just want you to be aware.
All right, I understand what you're saying now. All right, thank you.
Other than that, those are the
All right.
motions.
Great. Okay. For Mr. Huey, I have got a renewed motion for bond. Is there anything else for, I don't even know which party I'm looking at yet, but, okay.
That is the only motion that I've.
Okay. All right. Yes, thank you. Okay, so for Mr. Stillwell.
So, Your Honor, the way that we had been operating under this case, under the Honorable Judge Glanville was something. Yes, sir. Your Honor, the way that we had been operating under Judge Glanville was, it was a thing we named the Harvey Rule, which assumed that all were in agreement and opting into a motion unless we specifically opted out of the motion. So
Everybody is joined on everything.
Steele has filed a number of motions that we opt into.
Okay.
And Your Honor, I'll also just point out, there's also the gentleman who's on the stand right now. I think that we need to have a hearing regarding the admissibility of his testimony. I'm not looking at Mr. Steele's motion, but I too believe that we need to look at the co-conspirator exception to the hearsay rule and determine if that applies to the gentleman who is currently on the stand and what he said.
Yeah, everybody's
Okay.
bringing
And
towards
additionally,
Woody's testimony.
After Mr. Weinstein's recusal motion, we spent a significant amount of time going back and forth about prior statements and redacting prior statements. And I believe that
Prior statements of Mr. Copeland. Okay.
we would have to go through that process again because that was done after the Mr. Weinstein's recusal motion. So we probably need to relitigate that as well. Of course, if it doesn't fall under a hearsay exception, then we wouldn't have to do that. But
Okay.
Okay, somebody was asking about the retired
And with regard to the question of the admissibility
same
of
court recordings
Copeland's
from Gainesville.
statements under the co-conspirator rule, is there a pending motion or was there an oral motion? Has there been a ruling?
there was a ruling.
Okay.
I don't recall if it's been reduced to writing. I'm going to assume it was. But you know, we've litigated a recusal motion. We've talked about the appearance of impropriety at this point, and from our stance, we need to relitigate.
Are they passing
Okay.
notes?
Yeah, I mean, sure.
Are they passing notes?
Separate from whether anything needs to be reconsidered based on anything about the recusal, just with regard to like pure evidence. Was there an objection and a ruling
There was. It was.
before he started testifying?
There was.
Okay. And that's what you're saying
Hold on, y'all. Hold
should
on.
be.
Get into substance, but just to educate.
Hold on. Don't she look like a student in school where they try to pass notes and she acting like she not passing notes to the other person? Because Mr. Atkins passing the note and she's like, don't pass it now, right now. It's so funny. Okay, sorry. I had to do a little commercial break here. Hold on.
But is that what you're saying should be reconsidered? Okay. All right.
She
All
knows
right.
she passed
I
that
am
note.
not going to go back. I mean, this case has been going on for how long? 6 months, at least the trial part of it. And obviously I'm parachuting in and I'm just going to have to pick up from here and move forward. I cannot go back and reconsider every evidentiary ruling that's already been made. And I don't think that's what you're asking. I think you're saying because this witness is still on the stand. But I don't know, Mr. Botts, if you were about to say, let's reconsider everything, but we're not going to be able to do that.
Just all the rulings
On Mr. Copeland. Okay. All right. All right.
It's one of her staff that's sitting in the witness seat.
And let's see, for Mr. Ryan, and I understand everybody's basically joined in on everything we've already talked about. Is there anything that's individual or in particular to your client that I need to think about?
Yes, Your Honor. And hopefully the state will correct me if I don't have it correctly. But some of what specific evidence the state plans on using each witness has been specified somewhat on a rolling basis.
Okay.
I'm going to give an example. In Mr. Ryan's case, there are 15 recorded interviews.
Mm-hmm.
The state is not necessarily going to offer all 15. Within the ones they might want to offer, there are parts which are inadmissible. Everyone would agree they're inadmissible, but the state has not had a chance to sit down and specifically say, you want these statements, and here's what needs to be redacted, and go back and forth on them. So we've not crossed that bridge yet, Mr. Ryan. When we do, you'll have motions of that nature.
Okay, so I'm going to try, and we can maybe get to that in a minute, but I would rather everything that should have been a motion in limine get sorted out. I don't care if we're 2 months from that testimony.
Oh, you heard what she said? She don't care if she's 2 months from that testimony.
Yeah,
get
well,
things in
to the
order.
extent we can stop that, we're going to try to get everything done beforehand, but we'll
Yes,
see.
that's Little
We'll
Rod's
see. All right, thank you.
attorney.
And then who else have I still not heard from?
That's Bot
For
texted
Mr.
Weinstein.
I will, y'all, in a couple of weeks, I'll know all of this, but I just honestly have not been following this case up until now. So, Mr. Harvey, for Mr. Nichols. And I may need you to yell.
I'm sorry. Better?
Yes.
Per the rule we've been operating under, we're all in on everyone else's motions, barring a on the record opt out.
Okay.
So we're in on everything because we have not opted out as of this point on any of those motions.
Okay.
There may be, I to be honest with the court, I wanted to see where we were today, what our plan was. There may be some additional motions that would be filed on behalf of Mr. Nichols and perhaps other defendants. If we're going to view this as sort of a logistical status conference, based upon prior proceedings, we've mentioned certain things. We've mentioned certain cases about what may or may not be valid or evidence post motion to recuse. There may be some additional motions that need to be filed. So I would ask that on behalf of Mr. Nichols, that not only we're opting in and we need to now think about whether or not there's going to be any specific opt out, but to give us some time frame to file any additional motions based upon the unusual proceedings and circumstances in this case moving forward.
All right, so I'm not going to be able to give you a blanket, hey, you get X amount of days to file whatever you want here, because I don't know what it is that you might be contemplating. And frankly, there have been, at least a week and a half that's gone by since whatever the ex parte was that caused all of this. It may be that it's appropriate for another motion to be filed and be considered. It may not be. I'll kind of have to wait and see sort of what it is and why it is only now that it is going to be filed. So I just can't give you an answer on that before I know what it is. But I mean, I'm certainly not precluding anybody from filing. I just don't know if it's, if it's something that could have been filed 10 months ago, then I probably don't want to hear it now.
No, I think these circumstances are unique, clearly. So it presents unique opportunities to now move the court now that we have a court. I just
okay, so why don't I just say that if you are contemplating anything, contemplate it quickly and get it filed
5 business days
before the end of next week, because and I want us to all look at a calendar in a few minutes, but the jury has already been given the week of July 29th off, so they won't be back before August 5th, really. So I would like for us to, if we're going to be moving forward with this case, to be able to move forward with it and have all of whatever this is going to be out of the way before then. So if you can honestly, because I would also like a response from the state on anything that gets filed. So if y'all can, given that you've had already, a week and a half since whatever went down. I don't know the exact dates of everything yet, but you don't really need 5 more days to think about it. I'd like y'all to get anything that you're going to filed by the 23rd, which is next Tuesday. That may make for busy weekends for y'all, but
by next,
that is what it is. And then I want
responses
from the state by that Friday, the 26th.
Oh, she wants response by the state by Friday.
Which does not mean I'm inviting them. It just means if there are some necessary ones that we need to consider, obviously I want them briefed by both sides. And then we'll probably spend the week of the 29th we'll all be here without the jury trying to get as much done as possible, I think. Okay?
And that may answer my next question. I know that on behalf of myself, and I know various other co-counsel, I mean, as soon as the words "we're in recess" were uttered, I have emails, specialists at trials. I mean, I am inundated by other both federal judges and Superior Court judges. I am asking for protection, and I would assume that co-counsel would join in this protection so that I can say to these other judges, I am on trial. I'm required to be participating in this court, and you cannot set me for trial in another court because I'm on trial. Can we get that protection from the court?
Yes, you shouldn't even need that because we are in the middle of a trial. I don't care whether the judge has changed or not. This trial is ongoing. But yes, to the extent that any judge calls at my chambers, yes, I will tell them, sorry, you can't have Mr. Harvey right now. I've got him.
I want to make those representations in conflict letters. I want to make sure that I'm doing that properly.
Yeah. Now, if there is, because I have been until recently one of the people trying to get a hold of all of y'all for other cases. So if we decide we're taking a 2-week vacation in August, which we won't be, but hypothetically speaking, and y'all aren't in here with me litigating something, then for a 1-day hearing or something.
Yes. I don't mind the 1-day hearing. I do mind going to trial when I'm
sure.
on trial.
Yes.
So with that,
y'all are all protected from being expected to be in trial anywhere else until the completion, however it completes, of this trial.
Thank you. Thank you.
All right.
Your Honor, Doug Weinstein for Mr. Kendrick. We have no pending motions other than what has already been stated by our defendant's counsel that we all join in. We will be filing motions before Tuesday, but we have no pending motions. And you said we are going to discuss calendar moving forward? Yes. Okay, I have some comments with regard to that.
Okay. All right. All right. Turning to the state. Are there pending motions by the state that need a ruling?
Thank you, Your Honor. There are, and we will have to the court before Tuesday of next week, as the court has
take
made
a look
a
at
deadline.
her. Take a look.
There are responses to recent filings by some of the defendants that the state anticipates it will be making. And there are 2 anticipated motions in limine that we will have filed by Tuesday.
Okay.
Based on the court's earlier instruction today, there were matters that are more appropriately placed within a motion that we will have to the court by Tuesday as well. There are, and we will identify all of the ones that we believe exist. There are outstanding, there are rulings that have been made long ago by the court that may not have been reduced to writing. We are working towards identifying each of those, as well as putting into a chart for the court a list of the motions and rulings that have previously been entered.
That would be fantastic, because while y'all all know what the rulings were, I do not. So yeah, a chart and some further information would be great. That was on my list
she offered
as
a
well.
chart, right? Now listen to this.
Of course. And we also intend to we can do that in the context of a motion, or the court, if it is appropriate today, can address it. We would like to
Listen, you hear how she tried to tell the judge to do some sort of ruling. Hold on, y'all. How she used to do with the Judge Glanville, but I don't think this judge's gonna take that.
present to an exchange with counsel for each of the defendants what we believe and what we have kept a record of, all of the exhibits that have been tendered, ruled on, and admitted so far.
Okay.
If that is more appropriately addressed in a motion, I can do that, or if the court will permit us or schedule for us a deadline by which to exchange exhibit lists, because the state currently has an exhibit list that we believe is thorough.
Okay.
That includes the exhibits that have been tendered and admitted by both the state and each of the defendants.
Okay. And do you have that like with you and ready right now?
No, we want to present that to the court.
Okay.
We want to compare it with, if the defendants each have one, compare it with those. We want
the funny thing, she's given a thing that she supposedly have, right? Then she said, well, do you have it right now? No, I don't have it. I'm just bluffing. I'm just bluffing.
To be as accurate as possible before we present it to the court.
Okay. So do y'all want to maybe, it sounds like outside of a proceeding, y'all all get together and do that? Or, I mean, if we want to all do it in court, that's fine, but it's not a bad idea.
I would have preferred that the court just ordered that each of us present to the other the exhibit list that we have, to the extent that they do exist, and that we then endeavor to iron out any differences or discrepancies. So that, for example, by next Wednesday, we each give to each other what exhibit lists that we have, not anticipated exhibits, but the ones that have already been admitted and ruled upon, because there have been moments where exhibits have been shown to a witness or spoken on, and the tendering party represented that the exhibit had already been admitted, and upon closer inspection, the exhibit had not been admitted.
Okay.
So we are asking for a date from the court.
Okay. So when can you have yours ready to dole out to everybody?
We can have ours ready by Tuesday, if we can exchange them by Tuesday.
Okay. Is it, I assume everybody's been kind of tracking this. Could everybody have what you think is the state of the evidence by Tuesday?
She laughing.
Hard to do. It's okay.
I mean, frankly, whatever the court reporter has is what's accurate. So it might be that I can just get that list from the court reporter and give it out to all of y'all. And if there is that might be a better way to do it. And then if there is a discrepancy and anybody believes that's inaccurate, we can take it up. So why don't I talk to and we're going to be, from now on, well, y'all all know Miss Parker, but Miss Parker is retiring in 1 week. I will have a new court reporter, and I know, it's the end of an era, but I'll have a new court reporter, Miss Winfrey, who probably a lot of y'all know anyway, and she'll be moving forward. I'm going to ask Judge Glanville's court reporter to start working on transcripts, because I'm going to need them, but we'll all need them at some point probably, because just transcribing what's happened so far is going to take months and months. So we're going to shift not only judges, but also court reporters. So I will get with Judge Glanville's court reporter and ask her to give me a list of what has been tendered and either excluded or admitted or is still hanging out there. Give that to all of y'all, probably just through email from Ms. Rosser. And then if there is any discrepancies, y'all can let me know that, okay?
That would be great. Does the court, and I understand that there's really no way to tell accurately, but does the court have any idea of when
Ms. Parker says
we could anticipate receiving something
I
like
think
that?
pretty quickly. I mean, I've had a couple of communications with her already, and she seems pretty on the ball, and she's tracking it all on an Excel spreadsheet. It won't take long. I think I can get y'all that by next week sometime.
Thank you.
Okay. Let me write my to-do list.
Okay.
I don't mean to laugh, y'all. But he did all that speech, and the judge said, "No, I do it." And she laughed at it. Don't play me.
All right, what else? Your Honor, I'm reviewing all of the notes from representations made by counsels for each of the defendants. And based on my review of those notes, I don't believe that there are other matters that we need to address at this time that are properly addressed without the defendants here.
All right. And do you have an idea of when you can get me the list of the rulings so far?
Yes, Your Honor.
And I know that's a bear of a task, so
that's okay.
Don't want to be unreasonable about it.
Yes, I know that's a bear of a task because I ain't gonna do it.
If the court will permit me to confer with
sure.
our team members who are working on
Lying
it.
to me.
Thank you.
I'm sorry, y'all. Be professional. The judge said, "Stop lying to me." Look at the staff attorney. Look how she's sitting there looking. She got her hand folded. Look how she's looking over there.
Actually in on this case, or are you just standing in for Mr. Williams today?
I'm actually in on the case. I did file an entry.
Okay, thanks.
Don't go, y'all. I'm sorry. I don't mean to laugh. I was paying attention to the judge. I didn't see all of this before. I'm just enjoying it right now with you guys.
And Your Honor, I know that we can have that list before next Friday, or at least by next Friday.
That'll be great.
Okay.
Thank you. All right. With regard to the most immediate scheduling, the kind of
Okay, sorry, y'all. She got ready to say something. She didn't realize the judge has moved on. Y'all want to see that part again? Hold on. Wait a minute, y'all. Watch this. She got ready to say something else, and then she realized, God, the judge said, all right. So she went and sat down. Hold on.
Bro, you tickled to death, huh, Sylvia?
I didn't realize this earlier.
You just as tickled that don't make no damn.
Sylvia, I was laughing too because I was listening earlier, and now I'm seeing it, and I just bust out laughing when I saw that. She even threw a face with it, girl.
Let's let it ride, Sylvia.
I'm sorry, y'all. I'm sorry. I don't mean to be a professional, but y'all, she got ready to say something. When it just all right.
We are human.
It was okay.
I am not an alien.
Look, this why your ass ain't getting no hug this morning. This is exactly right.
Stop cursing, Jay. Y'all, no, just watch her, y'all. Watch her when the judge said, all right, she got ready to say something. But it seems like the judge said, shut up. Good, go sit down. Hold on, y'all. Just watch what I'm talking about, y'all. I just happened to see it. Hold on, y'all. Watch this. Watch her.
all right. With regard to the most immediate.
We gotta do it again. Hold on, we gotta do that part again. We gotta do that part again from the beginning. Oh, did you see what I'm talking about? Hold on, I gotta show you the whole part. Hold on.
She should have said something faster.
Just say something to her and just say, all right. She's like, oh, she put the pen Watch this, y'all. Watch. Just watch.
Actually in on this case, or are you just standing in for Mr. Williams today?
I'm actually in on
Okay.
this case. I did file an inquiry.
Okay, thanks.
Watch her, y'all. Watch. Slowly watch her. Watch. Look what if she said she pick up a little paperwork and set up. Just watch her, y'all. Sorry. Look, watch her, y'all. She did all that. Watch.
And Your Honor, I know that we can have that list before next Friday, or at least by next Friday.
That'll be great. Okay, thank you. All right. With regard to the most immediate scheduling, the kind of getting through, hearing argument on, getting rulings on the things we all just talked about that are pending. Is everybody available and I guess I've already got y'all. Unless Judge Glanville had excused you, I think I've got y'all, but is everybody available? And I'm not saying we're gonna be here 8 to 5 every day, the week of the 29th, but is the week of the 29th, everybody's available to the extent we need all of those days? Okay. Anybody not? Okay, perfect.
Hold on, sorry, y'all. She went up there to say something else. AJ, did you see that? She went up there to say something else. And then
She looks so defeated. So defeated.
said what she had to say. She was supposed to sit down, so she went back up there to say something else in the dressing. All right.
You don't see all that. The love you seen before is not the love today.
Jeez. I'm not gonna get no more hugs, y'all. I'm not gonna get no more hugs. I promise you. I'm sorry, y'all. Golly. my hugging days are over. They're done with me. But okay, one more time, y'all. I'm sorry. Those who hate me for doing repeat, but I just gotta do this one more last time, please. One more time, please. One more time, because y'all, she already finished her conversation with the judge. She should have sat her butt down, but she got up, went back up there. Then the judge said, "All right, that was." Oh Lord, y'all. Oh Jesus, help me, please, Jesus. Okay, hold on. All right, watch. Last time, I won't do it no more. Won't do it no more.
And Your Honor, I know that we can have that list before next Friday, or at least by next Friday.
That'll be great. Okay, thank you.
Okay, now she's finished, right? So she's gonna come back up there again.
All right. With regard to the most immediate scheduling, the kind of getting through, hearing argument on, getting rulings on the things we all just talked about that are pending. Is everybody available and I guess I've already got y'all. Unless Judge Glanville had excused you, I think I've got y'all, but is everybody available? And I'm not saying we're gonna be here 8 to 5 every day, the week of the 29th, but is the week of the 29th, everybody's available to the extent we need all of those days? Okay. Anybody not? Okay, perfect. Because I'm thinking that at least most of that week, that's what we're gonna be doing, which means I am not going to be going to the judges' summer conference, but that's okay. That's okay. Okay. All right.
Sorry, lovely.
With regard to kind of further in the future, just when we're going to be having a trial, I think it's maybe been like 4.5 days a week or something. I don't know. I guess it doesn't matter what it has been. Here's what I'm thinking. I am thinking that when we are in trial, we start at 8:45 and go to about 6, at least until the time changes and it gets dark early. And I'll have to obviously make sure that all the jurors can do that. I don't know what their, pick up kids schedule is or anything like that. But I want to make the most of our time, like I said, while we're here and have them. So that's kind of going to be my plan going forward. And it may be that we want to go
You look at that.
all 5 days. It may be that we want to, break at lunchtime on Fridays. And if we have other business to do, we stay for the afternoon. And we may not start August 5th with the jury. We may have so much left to do still that we give them another week. But once we do start back with the jury, I'm thinking 8:45 to 6. And when I say 8:45, I mean 8:45. I intend to
8:45
take the bench at 8:45. I expect I know that the parties, the defendants will be here because the sheriff's office will have them here. I want all the attorneys to be here as well. And if you have 5 attorneys on your side, as long as one of them's here, we're going forward. Okay? So I don't want to be waiting around till 9:30 to get started. 8:45. All right, so that's that. So a couple of things have been brought to my attention that some people might like changed.
It's squealing now.
That we're have a fresh face. And y'all, some of these are really kind of insignificant, but I'm gonna go ahead while we've got some time and bring them up. Food in court. Everybody can have water whenever they want to. The attorneys can have, whatever drink they want to, as long as you're not klutzy like me and don't spill it all over everything. I guess if you do, that'll be your problem. If we are working through lunch and the jury's out and we're working and y'all are here and the clients are here, that's okay. But snacking while trial's going on, we're not going to be doing that, okay?
No
so
snack
if we are
while
working through lunch, if we are working late and it's dinner time, it will be okay to the attorneys or the defendants have food. Not while somebody's on the stand testifying, okay? We're not at a movie. We're not gonna be eating popcorn. All right. Hopefully that'll be all I have to say about that. Apparently, one of the first things that I don't know how many different deputies told me was the
she told the deputy. It's the deputy who told her.
Clients has gotten a little out of hand in terms of how much they all have now. So, I don't know, but y'all need to maybe get together and let's exchange most of that. And sure, they can have new outfits for court, but it sounds like they're like full wardrobes full of clothing for some of these defendants. And that's just a lot for the deputies to have to keep up with. So how about if y'all check in and maybe through Miss Rosser, y'all all know Miss Rosser, I think she's not even here today. Yes, she is over there. Miss Rosser, my fabulous litigation manager. And let's make sure that it gets whittled down to a manageable amount of clothing.
Ross, like litigation manager.
There are only going to be 5 days in each week. So even if they had a different outfit every day, that would only be 5 outfits. Okay, we shouldn't have 20 different outfits for anybody. So y'all need to clear out apparently the closet. So now I've done that for the deputies. They'll be more happy. Okay, next topic. Minimizing disruptions in court. I don't exactly know what that means yet, but let's try to conduct court in a way that minimizes disruptions. And we'll just leave it at that for now.
I don't even know what that is.
There was an issue about apparently, and I'm not even sure if I understand exactly what has gone on with this, but the defendants listening through ear pods to things on laptops while court is going on. And I'm not sure I understand why that's happening. And that raises some security issues with our security staff, with the sheriff's office. So can somebody kind of explain to me what that's about and why that's necessary? And if nobody wants to, then we'll just do away with it.
They brought it to her attention, y'all. She's just addressing it. The sheriff department did.
All right. Well, we won't be bored from here on out. So then if that's the only reason for it, I want to be moving forward efficiently and expeditiously. So let's just plan to not have that happen anymore. And if there arises some new reason for it, then we can address it again anew. Okay? Yes, sir.
Good morning again, Sergeant Master Mr. Huey. There are times where the defendant might need to listen to evidence, interviews, things of that nature. And I've made that available for my clients to listen to some of the interviews from witnesses, testimony, prior interviews, things of that nature. For evidentiary purposes, that would be a request for my client to be able to have that access where necessary.
So why is that happening in court? That seems like something that should happen after hours between the two of you.
Well, they don't have the access.
Maximizing the time that I have with my clients since I don't have availability with him outside of court every day. So he's here, we're here. So a lot of times I'll give him an opportunity to review evidence and things of that nature. So
All right.
That would be the only reason I would ask.
I'm going to ask that you try to get that done outside of courtroom time. And if there is some sort of an emergency, unexpected reason why something can't have been reviewed before, then you can bring that to my attention. But okay. All right. I would like to find out from kind of everybody how many witnesses there are to go and what you expect those witnesses to say. And one reason I say that is because Judge Glanville had entered an order, which I may not have brought downstairs with me, but y'all, when I describe it, will probably be familiar with it, that essentially said everybody, not really, but several parties have asked for mistrials, I think, because things are moving so slowly. And he entered into an order that seemed to say, it appears that the state has 200 and something witnesses. We're on 50 something now. Everybody's causing disruptions, or not causing, but there have been a lot of disruptions because a witness is on the stand and all of a sudden one party or the other comes up with some video that nobody's ever seen before. And that's the reason for all of this disruption. But at the same time, you know, maybe some of this can be whittled down. And that is a wild paraphrase of that order, but I think you'll know what I'm talking about. What I want to know is, where are we really? I mean, I know, you know, witness lists look one way before the trial, and who you end up calling oftentimes ends up being something different. I know this is a multi-count indictment. I know that there are a lot of defendants involved in several different incidents. And I don't expect this right now, but I would like from everybody, to the extent the defense knows whether they're going to present a case or not, a realistic list of witnesses, maybe like what counts they go to and what you expect those witnesses to say.
Shaking his head yes,
generally,
and
broadly.
Hilton shaking her head yes.
Because
Love hasn't
this
shaken
case
her
has
head.
been going on for a really long time. And there is a rule that lets me exclude cumulative evidence.
Uh-oh.
And
Did you
I
hear what she
might
just
end
said?
up using that.
Oh,
So how about
she
y'all
said,
give me a
hold on,
heads up
hold
on
on,
all of that?
hold on, hold on.
Okay.
Did you just hear her say, Renee, did you just hear her say, there is a rule that lets me exclude cumulative evidence?
Yes, ma'am. It's rule 403. I can tell you what rule it is. Finally, this looks like what I've been learning in school.
Oh, she said there is a rule that I may exclude cumulative evidence. I may just use that.
All right now. All right.
She's talking directly to the state at this point.
You hear what she said? There is a rule.
She's been talking to the state since she hit the door.
Yeah.
Well, excuse me, since she got on the bench.
She said there is a rule that lets me exclude cumulative evidence. I may just use that.
Georgia has a 403, is a federal rules of evidence, rule 403. Georgia adopted the federal rules of evidence. And yeah, it's called 403. I had it.
How many times the defense have asked Judge Glanville that 403? I've heard them say that thing.
Girl, I told you, you helped us get through evidence and advanced evidence. Thank you, Sylvia. Just wait, girl. We got you.
Yeah.
And you know what? He will always say, overrule.
Overrule.
Yeah.
And she just said, I may have to use that.
She was letting Love know that I'm not going to accept that. Dwindle down this list. I don't need the same. I know.
You just went out. Did y'all hear him?
Yeah, he went out.
He went out. AJ, you went out. You went out, AJ.
Stop the mess. It will stop the madness, the cumulative stuff. In fact, still often has said 403, Your Honor, this is more prejudicial. And Ms. Love will get up and say, well, Your Honor, this goes to the weight. She's giving it to the jury, basically. And it's like, no, this has nothing. You're talking about apples, and we talking about, he testified about orange.
But y'all know the other guy, he wanted anything bad to come in. Anything bad, even if it had nothing to do with nothing. He wanted the jury to hear it because he was a professional jurist, as he liked to say. So...
It's all about discretion, and judges have wide discretion.
But did you hear what she said?
I think she will use it.
She said, I might just use that. There is a thing called cumulative evidence. I might just use that.
Yeah, she don't want to listen to 15 hours of jail calls and interviews. Like, come on, man.
Oh God. Okay, y'all. I am so sorry. Those who hate me being repetitive, but I'm one of those type of people that's like a teacher. Sometimes you have to say things a couple of times to get in people's head so people can understand and not miss anything. So please forgive me if that's annoying to you, but I'm petty like that. Sorry.
And if that is something that y'all could have to me by next Friday for everybody, that would
Friday, everything. She wants everything Friday.
Let's see. What's next on my list? With regard to kind of just general scheduling, other than the week of the 29th, and then I was told... I think Monday through Thursday of August 19th through 22nd. Is anybody aware of time that has already been given to the jury as you're out of court this week? You have this week free? No? Okay. All right. Does any attorney right now know of a date that nobody from your team can be here? And I wouldn't expect that to be the case because y'all are in trial, but no, I mean, anybody getting married? Okay. So I hesitate to even say the next thing I'm going to say, but I'm going to say it anyway.
Oh, here we go, y'all.
the little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot and that people have been maybe less than professional. And I hope that this kind of breather has given everybody a breather, and everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that, okay? But if it gets to a point where I think that is not being carried out appropriately, we're gonna all have to talk, okay? All right.
She said we're gonna have to talk. Okay. All right.
All right. What else do y'all think that I need to be thinking about, or do we need to be talking about, or at least raising?
Use my word, y'all. So that's my lady right there. I like her.
Anything from this?
Y'all know I always use the word y'all. She used that word too.
I believe that the court has sufficiently addressed everything that we had anticipated we needed to address with the court.
Okay. All right. Mr. Weinstein?
No, Your Honor.
Okay. Mr. Sharp, anything?
There have been, this case, as you know, is enormous, and the discovery is enormous. There are
He's a troublemaker, y'all. He's a troublemaker.
With Judge Glanville, we have some general rulings about some matters, but not particulars.
Okay.
Let's see her face. Let's see her face. Hold on. Let's see her face. Hold on, y'all.
Situation. I have filed a motion regarding, there was a wiretap in this case.
Okay.
And look at her face. Look at her face, y'all.
The judge overruled my
Animated, y'all. Look at her.
and stated that the wiretap was legal. He made that finding. However, there are other issues about the wiretap and the particular things said in the wiretap. Some of those pieces of communication may be admissible, may not on an individual basis. Certain things like that, I'm just giving the court a heads
There she
up.
goes, shaking her head, y'all.
Parsed through to the particulars.
Okay.
And we've discussed like the need to do those things, and some of those things we've kind of kick the can down the road a little bit. So they're still outstanding.
Okay.
I just wanted to bring it.
All right. So
look, she's trying to go
maybe
in.
when everybody is putting their lists of witnesses and what they're generally going to be talking about together, they could also include if there's any kind of either voluminous evidence, video evidence, audio evidence that we need to be considering admissibility of before the witness testifies. If y'all can maybe list out for everybody what that is. Because yes, I absolutely want those things to have been determined before, witness Smith gets on the stand and we have 18 hours of some kind of video statement that nobody's thought about yet. I'd like to say I'm sure that all of the evidence has been exchanged by now. Would I be correct in saying that?
There's reports that we're still missing. The state has said that they had those reports. Officers have testified that they wrote the reports.
Okay.
And we're
The gloves are off,
All right.
y'all.
That's been a recurring theme.
All right. If everybody wants to detail anything that they think is missing, and I'll hear from the state on whether it is either missing about to show up or does not exist, that'll be something we can take up substantively, just so we start out all on the same page.
Hold on, put a pause on a minute. No more hugs for Sylvia. Go ahead, AJ. What you about to say?
Now, Love just gave up then, because that was a moment where with the other guy she would argue back, but you saw her mid She told herself, she was like, nah, she ain't going. Because Shar said it's been a reoccurring theme, man, for the last 6 months. We've been trying to get evidence in. I'm talking about Judge Whitaker came in throwing blows at the state on the way they've been running this case.
They say know your audience, know your judge.
Yeah, I'm sorry. Yeah, I'm just laughing because it's a totally different mood, a different
And the defense having a ball over there. They get to get it off now. They get it. It's a fair trial finally.
No, just because
You got to go back about.
we gotta go back and find another video that when somebody's up there talking, how she reacts. We gotta do that. We gotta do comparison and contrast and comparison, whatever it is. We need to do that.
It's obvious though. She can't control her body language.
She's contained, y'all. She's but now remember when that man was trying to talk, she stood up by him and by the podium. Remember when Melnick was trying to talk? She tried to push Melnick out the way.
Yeah. That's why she was like, I know it's been some, y'all got to respect each other, because she been seeing all that back and forth. She's seen it. How love be over talking people.
No more hugs for me, y'all.
It's over. You finna get dirty look.
Her look coming up. I'm waiting.
Oh yeah,
we gotta do the look.
It's coming right up in a second here. Yo hugs was done yesterday.
Oh my God. Okay, here we go, y'all. I'm so sorry.
Here it come.
Danae said, "Love is unhinged, y'all."
Oh, she wants to go rampant, baby.
Yeah, she can't go rogue no more.
Yeah, we gotta do a compare. Because tomorrow we're gonna take this video and we're gonna compare it with some other video.
Yep, side by side.
But it is a great example to the judge of behavior that is ethical.
Yeah, know your judge. They teach us that. Know your judge.
Okay, hold on, y'all. Hold on.
Baby, she want to fight.
And Chard is so messy. He goes to talk about the reports and like, Lord Jesus.
Hey, somebody in the chat mentioned Shard changed seats because he wanted the front row to this.
But
I noticed he sure did. He got right on up there.
Yeah, this is time to get it out. I knew he was finna say something about that. And she opened the door to it.
Okay, y'all. Here we go, y'all. I know tomorrow we're gonna have a good time because we're gonna do some comparison. Make sure y'all come early.
That'll be something maybe y'all can do next week, and we'll take up the week after that as well. Okay, because if we need like 5 days of motions in limine,
look at her face. Look at her face.
Okay.
Judge, I just wanted to make clear that it has complied with its discovery obligations, that we have turned over all of the discovery that exists in this case. And as the court is aware, discovery is that which we have so we have turned that over, and we've actually gotten and requested. We've sought from outside our office any other materials.
Sylvia, a motion just dropped.
I got it.
The court has instructed and
Okay.
provided to the court.
I'm getting everything.
Matters we believe have been unaddressed still as they pertain to our requests for reciprocal discovery.
Okay. And Mr. Shard, I know you've been in my courtroom before, and typically I have, one side or the other list out specifically what they think is missing, and we inquire about it and try to get to the bottom of it. So that's what we will do. Y'all make up the list, and then we will do that. We'll actually go through it in detail so that everybody knows what's going on and we all are on the same page. All right. And y'all, for any evidence that there hasn't been a ruling on yet that I'm going to need to consider the admissibility of, I obviously am going to need a copy of that. So if I've got 5 hours of some audio to listen to, I don't want to listen to that in court. I want to listen to that beforehand so that I know what we're talking about before we get to court to hash it out. So get me all of that as well. And that'll be more homework for me to do. Okay. All right, then, so let's go through anything, either Mr. Williams or Ms. Abasi for your client. Okay, Mr. Harvey, Mr. Steele.
No, not
Okay.
this time, Your Honor.
All right. Okay, the next thing I want to raise, and I have no idea what has happened before now, but I would like to encourage everybody while we are kind of in this pause.
Okay, let's look at the face. Let's look at the face. Y'all. Look at the face.
Talk to each other about whether there are any plea negotiations that might be fruitful, whether there is any room for movement by anybody on anything, any plea. I mean, I'm willing to entertain any kind of plea at any time. It can be a joint recommendation. It will be non-negotiated since we're in the middle of a trial, but it can certainly be a joint recommendation, or it can be state wants this, defense wants that, or it can be we all want to keep going with this trial. I am here to give everybody a fair trial and everybody a fair shake, follow the law. But I invite during this pause, if y'all want to think about that and talk about that, now would be a good time to do that. Okay. All right. So I think that y'all have a lot to do and I have a lot to do, and we will plan to get all of our filings and all of our responses in before the end of next week at the dates that I had provided. And why don't we plan to maybe not Monday, but Tuesday, the 30th. All convene here at 8:45 and just start tackling everything that got filed, okay? And we'll plan to go pretty much all day until we finish every day that week. And by the end of the week, I'll know whether we are at a spot to bring a jury in or whether we need another week. All right, anything else from anybody?
I have a question, Your Honor.
Yes.
The court instructed that we provide the court with evidence for which there may be admissibility issues.
Yes.
I wanted to ask for the court's clarification if that meant whether there have been prior motions to suppress filed, or if the court is instructing that notwithstanding the absence of a motion to suppress on a particular piece of evidence, that we are now going to be entertaining motions to suppress. For instance, if there's a recording that we have turned over, will the court be entertaining motions to?
So I don't really know what the expectation has been. I mean, if this had been my trial from the get-go, we'd have litigated all the motions to suppress by now. Motions to suppress shouldn't really be getting filed mid-trial. That being said, I would rather, if somebody is going to stand up and say this is 100% unconstitutional for X, Y, and Z reasons, I shouldn't be letting in something that's unconstitutional for X, Y, and Z reasons. So I'd like to know it, but I mean, I want it to be a legitimate, valid concern evidentially, constitutionally. I don't want it to be, here's my chance to challenge everything under the sun. So I don't know if that answers your question, but it sounds like there are chunks of evidence that everybody has just basically not gotten to yet. And y'all sort of said, all right, we'll get to that when we get to this witness. And if y'all have been operating on a kind of rolling, all right, when we get to this witness, we'll deal with that evidence, then I don't, if that's what the expectation has been, then I wouldn't expect y'all to have all filed all of your challenges. I don't know what's been going on.
Your Honor, that has not been the case.
Uh-oh. Uh-oh.
But because of the way that
Uh-oh.
the court,
The judge laughed.
The court wanted parties to provide evidence regarding admissibility issues. I just wanted to make certain that I understood what the court was instructing. There have been evidentiary issues that I believe the parties disagree on. The state disagrees with counsel for defendants' interpretation of what is ripe and what is valid for contesting at a particular moment. I don't doubt those will continue to arise. I was asking as it pertains to what the court instructed just a second ago regarding evidence. I didn't know whether the court was doing something different than what I.
Okay, so I don't intend to revisit rulings on evidence that's already come in. But for evidence that we know is out there and was going to be introduced a month from now with, you know, witness Jones, if y'all been doing that on a rolling basis and y'all know that there are going to be evidentiary issues,
When
I
kept
that
telling
I
you
would have
Adam was
considered
standing
motions
up,
in limine,
about to come up,
then
but,
I
he
want
stepped
us
back
to
down
all
and he came
go
back
ahead and
something.
voice that now and sort it out so that we know when the witness shows up,
See,
what can be
Adam,
talked about and what can't be. And I don't know if that gave you clarification. Okay. All right, Ms. Abbasi.
Yes, Your Honor, if I may, I have to disagree with Ms. Love. It's been going along that we've already had motions about what is not admissible. Just to propound on kind of what Your Honor was
Even the
mentioning.
new girl called out Lil.
The task of defense cases, we have a list of 8,000 jail calls. We haven't listened to 8,000 jail calls, and I think probably the majority of them are not relevant.
Uh-oh. She just told on her. There go that voluminous stuff.
However, defense or burden, if we don't raise the objection, it's been waived, and then it comes in at trial.
Okay, so that's why the witness lists with what this is relevant to and what evidence is going to be used is going to be, I hope, very helpful in giving us all a better kind of groundwork.
Yes, Your Honor, that is precisely what I'm asking.
Okay.
20,000 pages of Instagram, it's going to be these ones.
Okay. Okay.
And Judge,
Yes, sir, Mr. Adams.
good afternoon again, Judge.
Oh,
Keith
look at her
Adams,
face.
Mr. Steele for Mr. Williams. Just to, I think the court wanted to know if there are things that Judge Glanville had been doing in regards to that particular issue. And I did want to just append to what Mr. Barnes was saying. For example, there have been jail calls, there are interviews that generally speaking, there have been hearings on the admissibility of those statements.
Okay.
But the court has oftentimes said, I agree that, for example, this statement may be admissible, but there may be some things in the statement that's objectionable.
Sure.
We'll deal with that.
Okay.
At that time. The court has routinely been doing that. So not necessarily kicking the can down the road, but addressing issues as they come up. And the court has urged both sides in advance of that issue coming up. If we can get together and iron some things out, let's do it. We've been working to do that, but there have been routinely times where we simply just disagree and we've had to take those items up. And I think what you would like, what Judge Landfill has asked, is that let's let you know about it as far in advance as we can. That way we can.
Her eyes. Did you say you heard that?
Absolutely. I mean, that is, I want to be respectful and cognizant of the jury's time. I also want y'all to all know what to expect to the extent you can, and litigate everything that we can litigate beforehand, if it's going to be necessary. Now, if there's some totally irrelevant Instagram post and the state knows they're not going to use it, but they listed it a million years ago.
Their
updated list that they're going to share with everybody should not include the Instagram posts that they know they're not going to use.
Yeah, y'all see that, y'all?
All right, so I will expect whatever filings I will anxiously anticipate all of them. Make sure
Hold on.
whenever you file any.
Hold on. Renee, would you like to give us the honor of explaining what she just said? Because somebody asked for us to stop.
What did they ask? I'm sorry, I've been listening to her, and what popped in my head a second ago was lots of hyperbole. Sounds like somebody I know.
Well, she's basically saying that she don't want none of that crap that there's no relevance to the case.
Especially if it's from a million years ago. So she probably roughly saying what, about 8, 9? Kick it out.
Exactly.
It's out of here. You know what shocked me was when I think it's a motion to suppress out there about Jeffrey's conviction. Now, Sylvia, has he ever been convicted of a felony as an adult?
No.
So so they're talking about bringing in his juvenile records? Because that's another thing. I'm like, why are we having this conversation? Unless he killed somebody, why are we talking about somebody's juvenile records?
Yeah, because they're supposed to be suppressed. It's supposed to be anything before the age of 16, right?
Well, in Georgia is 17.
17.
I believe they wanted to. Didn't they want to bring in all of his arrests at some point, Sylvia, but still blocked it?
Yeah. Okay, well that's good because I was like,
because they know he has no felonies. All he has is misdemeanors. That's the point.
Misdemeanors, yeah. And the thing that there was one as an adult, but they threw the case out. Remember?
Right.
Well, it sounds like we have lots of she structured. What hit me hard was when she said violating their constitutional rights. How many times? Yes, how many times has Brian Steele and others argued this is a violation of the due process clause? This is a violation of the confrontation clause. Those are constitutional rights.
But he's not Miss Shun too. He's not charged with the murder. He's charged as part of the RICO, which is saying that stuff that other people did, they put in as part of him as well. But he's not charged with actual murder.
Well, I was asking. I guess I said murder because I'm like.
No, somebody put in.
Oh, okay, got you.
No, he was not charged with murder.
But if it's a felony, then yeah. So that's why I was like, okay, was it a felony? And then you said no. So I'm like, okay. But when she kept saying their constitutional right, she ain't talking about state law. She's talking about your constitutional rights, which is often you violated. You searched and seized something you wasn't supposed to. You didn't have a warrant for that. You talked to me when my attorney wasn't present after I requested one. You know, she's talking about some big things that man have argued, especially about evidence coming in.
Yeah, I mean, the whole defense has been fighting against the other guy this whole time because he's been allowing this to happen, unconstitutional things that now we see another real judge won't allow.
Yeah. No, Shuntu, no, murder was never his charge. He got charged for possession of gun. He got charged for...
He got RICO and a bunch of drug and gun.
Yeah, drugs and gun. He's never been charged with the murder. The murder is Shannon and Nichols and somebody else. I think...
prove that.
Drugs they've been talking about is using them. So what we doing here?
Yeah.
And then those were new charges, right? Still, that came from when he got locked up. When they arrested.
Yeah, he got 8 charges. At first, when he first got charged, was just 2 charges. Then he got 8.
Yeah, but all of that is time served, beatable. Man, let's get this RICO out the door, man.
Yeah, RICO's the only problem that's holding them together with the other people's crime.
But from her tone, from Judge Whitaker's tone, she's not playing. Come next week. And also what stood out to me was her telling the state, let's get these witnesses together now. Ain't no more, let's put one on the stand. Let's talk to them for 8 days.
I said that earlier.
Let's get together. Let's get another witness. No. We're going to get everybody in line order today type of deal.
Okay, you see what intuitive says? Farley is charged with murder and he got bond. Definitely, yes.
And that's crazy, right?
Yeah, he got
What was
bond.
his bond?
$600 and something thousand.
Oh, okay.
Yeah.
Yeah, they're gonna have a very short witness list. Very, very, very short. Or maybe not have any witnesses at all.
Yeah, and then they're gonna throw the Woody's thing out, so that's gonna be messed up for them. It's gonna be done.
Well, I love the word the judge said, realistic list.
Yeah, she's not playing with this case.
Thing that you contemporaneously email a copy of it to Ms. Rosser, because the court and chambers do not automatically get what y'all file. I have no idea what you filed unless you actually let us know. So make sure that when you file it, you send a copy to Ms. Rosser so that we know about it. Okay? All right, so I'll plan to see everybody bright and early at 8:45 on Tuesday, July 30th. All right? Don't leave until you make sure Ms. Rosser has your cell information. All right? Yes.
Judge Glanville had, for both sides, 2 Fridays before that tell the other side what witnesses and what exhibits are going to be in play. I would hope that continues. That would be very helpful.
That sounds like a good idea. So sure, we can leave that as sort of a standing rule. And I suspect that this is true as well, but let me go ahead and say that as we're going through trial, I expect you to have your next witness ready to go. I don't want there to be a 5-minute pause between one witness getting off the stand and the next witness
Shots
getting on the
fired.
stand.
Uh-oh.
And the state knows, we're in the state's case right now. The state knows what it's doing. The state has investigative help.
Uh-oh.
Make sure you have enough witnesses to carry us through each day and that they're ready to go.
Uh-oh.
Again, that
I
all
said
just
that
kind
at
of
the
falls
beginning.
under the auspices of let's be respectful of the jury's time.
Uh-oh.
Mr.
Stop
Hardy.
playing,
Can I
y'all.
assume, Judge, that we are going to continue with the opt-out rule so that you're not going to
Yes.
get all 8 of us standing up going, I'm in too?
Yes, no, that's a great idea. Let's continue with that rule as well.
Thank you.
I mean, I plan to basically continue with the rules already in effect unless there's some reason to change them. So I hope if there is something, y'all can bring it to my attention. Otherwise, we'll just keep rocking as before.
Whitaker was
All right,
looking
thanks, everybody.
directly at
Remember the press, there was a rule in place for.
You know who that is, y'all, right?
Witness list on Friday, so if someone will be excluded to be shown on camera, I want to make sure that's still in place.
Turtleneck, y'all.
Okay, so I guess y'all would have agreed beforehand that a particular witness shouldn't be shown on camera. And then who gave the list?
The state has been providing to
Oh, here come that dirty look.
a list of those persons.
Here it go.
The judge has made rulings regarding those.
So I saw a ruling that said if there's somebody who, for whatever reason, shouldn't be shown, whatever kind of concerns, then they won't be shown in the, but
it wasn't exhaustive.
it seemed that was kind of a witness by witness thing and that there was an opportunity for input.
Yeah, there's an order that
Yeah.
the judge entered, and there were certain reasons that the
Right.
state requests that
Yeah.
witnesses not be televised. I believe that was to be provided to us the Friday before, and then we would have the opportunity to
Right.
object to that by Monday.
Right.
And then the judge would make a decision
Yeah.
based on his criteria, whether that witness should be shown on television or not.
Right.
And I believe that Mr. Harvey has a standing objection to all witnesses at this point.
Okay.
But
Wait,
anyway,
to all witnesses being shown
No,
or being excluded? Okay,
no
well,
witnesses excluded. I don't speak for Mr. Harvey.
all right.
And I'm in concurrence with
Okay, well, that's why I guess it's being taken up on a case witness by witness basis. So, Ms. Lowe,
She said
then
right back
you're
down.
providing that to the court and the opposing counsel. If there's objection, we're litigating it. And then are we saying it's like the next Friday that we then tell the press, or help me out on that?
Ms. Hilton says she has been providing that list. I will let her explain to the court.
Okay, because I guess I'm wondering, how is there a list if there hasn't been either agreement or a decision on it?
I believe, I'll let Ms. Hilton start, because she's the one that initially prepares the list.
All right.
Good morning, Your Honor, or
Good afternoon at
Your
this
Honor.
point.
What has happened is the week before, certain witnesses were going to come up the following week.
Okay.
We would identify any of those witnesses that we are asking not to be shown. We would forward that to the media as well as opposing counsel. They would then decide, object, and we would hear on Monday the ruling from the court.
Okay, well, so then with regard to the media's inquiry, it sounds like what y'all have been getting as a list from the state is kind of the preliminary. We think this might be the case list. But Ms. Hilton, do you then give them and here's what our determination was list, or?
So normally the court has put on the record that Monday, whether or not that witness should not be shown.
Okay, so y'all you've got your list and you either strike that person off because I said they can be seen, or you just go with what's on there. Okay, that makes sense. So yes, we'll continue with that as well. All right, we're in recess. All right, guys. Let's go ahead on and have our discussion. Listen, who blocked Coco? Unblock her. Whoever blocked Coco, unblock her, please. All right, go ahead. JL, go ahead.
Hello.
You're back.
I miss I think we went past the face, the look. It had to been earlier, but it was after like she had sat down one of them times, but it was on your live because I had tuned in on your live. It was your camera. That's what had me.
I didn't have my camera on today, so it was just the main camera.
Oh, that's how you were streaming it. Well, it was caught. It was nasty.
Did we catch it? Did you see it just now, or?
No. So he was saying it was right there at the end, and I thought it was at that end too, but somehow we missed it somewhere.
Well, we probably wasn't paying attention.
I'm gonna have to go back on the clip on there. How do you think the motions are going to come in?
What? And now they're coming in left and right.
Yeah, I mean, do you think that it's just going to flood from?
Well, she wants all motions in by Tuesday.
So I'm a little bit confused, and maybe you can help with this. So is she going to allow? I know she said like she didn't want to go over things that were already previously ruled on, but she said if it had violated their constitutional right, is she saying that, yes, I will address this again?
The ones that are constitutional, against the constitutional right of an individual, yes.
Okay, so that's going to be a really, really good one to have to see what's in there. The one that I am looking at is the lyrics. Using, because that was allowed in. And I thought any form of artistry cannot. I know for my state, anything lyric wise, anything artistry wise cannot be used against you. Which that's where it kind of got me a little bit confused, because sometimes they address him as Jeffrey Young Thug. That's his artistry name, though. And that is attached and filed, as an artistry name. They should only be identifying him as Mr. Williams or Jeffrey Williams or etc. They should not be using any artistry names. So that is interesting as well. What do you think about that?
Whether or not they use his artistry name?
I mean, yeah, if you really go back through the trial a lot, the DAs use his, use his artistry name versus his legal name. And if the law is you cannot bring lyrics in or their artistry in or their lyrics in, then how are you able to identify him in a courtroom under Young Thug if his name is Jeffrey Williams and Young Thug is his artistry name?
But didn't the judge rule for them to be able to bring it in at one point?
No, he ruled that it was allowed in, and that is what the entire defense had a standing objection. Weinstein had did a great speech on that. I might as well say speech because it didn't go anywhere, and it was thrown off to the side immediately. So that was interesting.
Mm-hmm.
Another interesting factor that I found is this report. Okay, that Grady, or I think Grady, is it Grady or Brady? The hospital.
Grady. With a G.
Okay, so the problem is that they said there was no investigator that ever reported to that hospital, correct?
I don't know if they said there was no investigative reported. No, there was two investigators, not the one that they said that was in. It was one person they claim wasn't, that never went there. But there was two others that did go.
Okay, so when that came about and that was proved wrong, because remember, DA Love was saying that that was not true, and then it came out later on that was true.
No, she was saying that that guy did not go see that particular gentleman in the hospital, and he found out that from the I think the 911 call, he found out that it was not the 911. Was it the radio interaction call? One of those calls. They found out that the guy did go to the hospital. Now, as far as who did he speak to, they claim he spoke to one person, but they saying it was somebody else, something like that. If I can recall, like that.
I was just looking at it and just, wondering, because it's so much to take in, going from, the damaging opening statements. You have investigators that, try to date a potential witness.
Mm-hmm.
You have investigators that have been caught falsifying. The initial warrant was falsified when they went through the details. None of those things is what played out. So that is an issue. The entire Woody interview is an issue with the ex parte.
Mm-hmm.
And then you have all these conflicts of interest from connections from previous dealings. And that's just the tip of the iceberg. And those are just a few things. I'm pretty sure there's 30 more other things to add to that list. But the biggest one, why everybody kind of went rampant, I think, tuning into this case was based off those lyrics being allowed in. So I was surprised to not really hear more on that, through these motions coming up. And I thought we would have automatically seen.
Remember, they're dealing more with what Woody's testimony is with these motions right now, with stuff that's just happening. I think Steele did put some motion into what the things that you were talking about, but that was back a few months ago.
Okay. So do you think it's the direction that Woody testimony is going to not be allowed in?
Not from the 12th. From the 12th forward, no. Only from prior to the 12th. which was the 10th only. Well, not even the 10th. Well, the 10th. That would be that would be the only one that they would allow in. Because once Mr. Weinstein motion was approved, everything prior does not count.
Oh, okay. Okay. So that does make sense.
But that's what the motion is for. That's what the motion for, and most likely is going to be granted based on what the the Superior Court sent to Weinstein. Remember?
But wasn't that just a guidance and no ruling?
It's not it's a ruling, but once they recused Judge Glanville, that made it more of a ruling, because now they got to go back to, because if you notice, 3 of the recent motions is talking about the same thing. Because of him being recused, that kind of helped with the motions that was put in for what's the name?
Okay. Okay. That makes sense. That makes total
That's
sense.
what I'm saying, because they're saying now Glanville's situation, he's recused based on what his answer is when he denied their original recusal. It's saying that that's where the wrongdoing occurs. So because of that wrongdoing, anything that was done prior, because he was a sworn witness, that they're trying to get to become obsolete,
Yeah. Okay. That does make sense. Then the other thing I had.
That's why all the other attorneys are hopping on that. And remember, Weinstein did it.
That's right.
Matthews doing it, Steele did it, and Shard did it. So
Okay, that makes sense. The other thing that I had went back and looked at was the interrogation of Woody when he was in there. And a piece that I found interesting is that the DA that was in there, the woman that was questioning him, a statement, she said, "I don't want to say too much or ask too much," something along those lines. Don't quote that exactly, but she said that she knew Mr. Melnick was his attorney. And I thought that was huge because of the big misrepresentation that happened in open court. That was basically proof right there that they did know that he was represented. That was another part.
Mm-hmm.
Did you happen to look at
the stuff
the 2 of the Georgia cases?
Not yet, no, because after I got off, I went to bed, and I was supposed to call you, and I never called you. So I still owe you.
I waited for you because I had something juicy for you that I couldn't put up in that chat.
Yeah, I am gonna call you. I just went to sleep because I was tired. So I owe you a phone call.
I got it. So if you could do that today, that would be great, because look, let me tell you, there's a little funny acting person out here, and I'm not going to put them out there, but we want to be respectful. And the one thing that I thought about, she ain't no wet food stamp. So I got to tell her. I screenshot and everything. Stop playing.
Okay. I promise.
Yeah, so it's just so you could see different things, but also I want to be able to put that other thing for your algorithm for you, because I don't know if you know, that's exactly what my company does. We build the businesses, basically get them up and running, and then also we put the funding behind them, and we give them the work to keep them stabilized. So like anybody that, is wanting to start their own, we get them lifted pretty fast.
Okay. Listen, Maj, you're asking me to put the link down. I already put it down. Y'all supposed to be copying and putting it in. So I don't understand.
Which one?
No, for people to come up. All right. Hey, Mr. Porter for Smile.
What's up, Sylvia? How you doing?
I'm good. How are you?
I'm great. I believe that Steele did that motion because he want to recuse the prosecutor, because if he
What motion
recuse
are you talking? What motion
it,
are you talking
the motion that he just put in,
No, but I'm saying you're coming up here saying a motion. I don't know what you're talking about, so please explain it first before you go ahead.
the Steele motion that he just put in.
Well, we haven't read that motion yet.
Oh, you haven't read the motion yet?
No. Mm-mm.
Oh, so I guess I'll wait. I'll comment on it when you read it. I don't want to, I'll wait.
Okay. Okay.
But overall, I think, I believe that the case is going to be dismissed based off of a lot of grounds that still put in that motion. Because, like you said, everything has to go back from what Weinstein did, and you can't re-ring that bell. Everybody will tell you cannot re-ring the bell. So it's going to be a lot of things that's going to be a give and take if this trial do move forward. And I just feel that either she's going to lose the prosecutor, or you're going to lose Woody Whole testimony, and that's going to be the cause of getting rid of the trial. So it's going to be on the state's point to be able to say they forcing the state to say we dismiss all charges opposed to a mistrial, because they was goaded into it. But then being that they was goaded into it, they want the state to do it opposed to them. So that's what I feel. But with Steele motion, I believe that is a lot going to happen. And I don't believe the reason why the defense didn't put a motion in, because if you look at all the motions, they put in a wait on one. Like the Weinstein put one in, Steele waited for to the 17th to see what he say about that. And then the judge recused that, then Steele put one in on the 17th. So when they put motions in like this, I believe they wait for one to be, because if it's a very important motion, I believe they all standing fast and letting Steele run the course just like Weinstein did his. So that's why I believe that the defense ain't do nothing, because they all in cahoots together. They talk like they said. They build a bond. They work very well together. They are a well-oiled machine. So they all piggyback off each other. So I believe that that's why the defense ain't file a motion yet, because they want to let Steele handle his first. What you think?
Well, a couple of them did file. You have Matthew filed a motion
For Huey's bond.
Mm-hmm.
And I don't believe.
Say it again. You went out. I didn't hear you. You muted yourself.
Sylvia, to piggyback off that before he comes back on, everyone has motions for bonds like two from previous denials, correct?
Say it again.
The bonds, there's motions from everyone from the beginning, correct?
Mm-hmm. Yeah. Well, it was like back in like 22 and then 20. I know DeMonte Kendrick and Jeffrey, last one was on 2023, July 2023.
Right, that's what I had figured, but I thought they did a standing.
They did a standing. I don't think it was for everybody.
Do you know who of the defense left that has not asked for bond?
All of them have asked for a bond. Every single last one of them. AJ, go ahead.
Oh, nothing. I was just, listening, and I was reading, the motions. I think the chat wants the motions, but I think in a footnote, guys, the first motion was just still not agreeing with Cross on the ex parte. She disagreed with the ex parte because of how the other guy acted after he got caught, not the actual meeting. So still is debating that. And then his other one was basically to strike Woody's testimony. And that's because had the ex parte not happened, then Woody would have never happened. So he has to strike Woody's testimony as well.
Which is the same thing we have been talking about with
Right.
the whole
Right. So those are the two motions in a gist. Y'all can go read them on your own, but those are the two motions that he filed.
You're going to do coverage on that though, Sylvia, right?
Yeah. Mm-hmm.
Okay. Because I don't want to get into the motions because I know that'll probably be your upcoming video.
Yeah, it's a little bit too. We're at 2 hours. You know what I mean? My 2 hours is I get like I'm at that 2 hour point right there. So
what's the status of them asking for a bond? Like, how does that does the
remember she didn't do any motions right now. She's gonna take care of all the motions after next Friday. She wants everything in so she can review these things and then make some ruling. But she wants the state to state whether or not they're opposed to it, and then she'll come back and give the answers to this.
Gotcha.
She'll let them argue over it, and that's going to happen the week of the 29th, the 30th.
So basically, today was just show and tell. Hey guys, this is me. This is
yeah. Hey, cute, I don't know how to say your name. Hey,
Pam.
Hello.
Saw Glass BG. What's happening?
I just wanted to say I believe, the defense set this up pretty well. I think they went into it knowing the angle to take. I do believe it's going to end in a mistrial. I believe the judge gave a preview of it if this case goes on. And I believe the defense was happy about her presence because they know it's going to be fair and just with the law being enforced. And if you go back to the beginning of when Still stood up and Love looked and started talking, she's fully aware of what's about to take place.
Mm-hmm.
I give big props to Woody because he was the one that blew this whole case up. It started from him and he ended it. And I do believe that it will end in a mistrial. Everything that has went on, all the biases, it goes further than just this case. You have to remember that this case was brought on early on before the Trump case, how Fani used their seized money to fund the Trump case. It was all, in my opinion, it was all planned from the beginning, and still knowing that blew it up. And that's just all I have to say about it.
Thank you. Shell?
Oh, I don't have a comment right now.
Okay. Maya.
Hey, Miss Sylvia.
Hey.
Quick question for you. Is this the judge that's a prosecutor?
You
or
just
you a prosecutor?
You just broke up. I didn't hear all your questions.
Is this the judge that used to be a prosecutor?
Yes.
Yeah. So for me personally, I just think people shouldn't get their hopes up high because they have this, to me, brotherhood. And I don't know. I just don't see her. Right now, I mean, she looks like, she's going to be like pretty standard as far as making everybody follow the rules, but I'm just not getting my hopes up high. I just know that judges who are former prosecutors tend to usually sway to the prosecution side a little bit more.
Not all, because if you heard what Adam said, he used to be a prosecutor too.
Yeah, but he's a defense attorney now.
Yeah, but he used to be a prosecutor.
So I don't know. I mean, I didn't see the look that she had gave, but I'm just like kind of not.
I understand your leeriness. I understand the leeriness of not fully trusting. I understand, which you have a right to do that. But I was just saying, I'd rather have somebody who operates and do what the law says, not leaning because somebody is your friend or somebody you know, but deal with what the law is.
Yeah, with the laws in front of them. I mean, I'm hoping that she does because the world is kind of like watching. But I'm just kind of leery.
But okay, even with your leeriness, based on what you have heard from her as far as what she wants from both sides, what is your thought? Not just you being leery, but
from what I've heard today, I think she's going to be fair.
okay.
I feel like what she's doing is what most judges would do when they come across an issue like this. They want to see kind of what both sides have or both sides stand. I mean, I think it's pretty standard when I hear judges say stuff like, we're not going to go all the way back and rehear every single motion, only if it's a constitutional issue. So just from observing her today, from when I'm in courtrooms, I think her response is like pretty standard and pretty fair. I was the rule when she laid down the rules of the headphones and no eating, I kind of laughed a little bit because I was like, okay. But for the most part, I it seems like she's just in the middle right now. Like she hasn't, she's just kind of like, this is what we're going to do, this is what we're not going to do. I kind of feel like there's going to be tension in the courtroom. I don't, when she said like she hoped that during the break everybody had a chance to cool off. I don't think they did, because when Matt Sharp, I think it was Sharp that was speaking, and Love stood up, I think Matt made a comment, then Love made a comment. I can kind of see the back and forth is going to start again. I don't think everyone's going to stay in their corners and be respectful. So I'm just curious to see like how she handles that. But from what I can see right now, I do think she's gathering. So I don't think it's like we can make a determination on how fair or not fair she's going to be, because she hasn't really done anything. Right now, she's just telling everybody she want the facts on the table so she can make a decision. So, but I just hope for everybody's sake, like she just stays fair and neutral. But I think it's going to be kind of, it's going to be kind of hard because Glanville's still her boss. So what, like if she goes back and
Glanville is not their boss. Everybody keeps saying he's just administrator. He's not their boss.
Yeah, he's like the spokesperson. Like if there was a committee type thing for anything, he's just like the spokesperson.
All right.
But I kind of disagree. I think she was very fair, and like what they was in court today for like 100 minutes. I think that she was very fair. Like you just said, the shit about the stuff about him, like, or her saying they can't eat anymore and use the headphones to listen to quote unquote evidence, stuff like that, and then saying the stuff about evidence for the state. Like I thought that proved she was fair. So I think she set that precedent where she like they're not gonna be able to do all that back and forth like they was doing.
But that's my thing. And just from your opinion, like what does headphones and eating have to do with being fair? That's just a preference, right?
That's not like a courtroom etiquette though.
She's getting the courtroom in order first. You have to get it in order first, and then we're going to get to the fairness of it.
But you got
you
got to also remember people bringing it to her, and so she's trying to address those things now, so they don't become an issue later.
Yeah, I felt like she was very down the middle. Like that's definitely not courtroom etiquette. Yeah, it looks cool, and like we want them to do that for sure. If I was in that position, I want to do it too. But that's really not courtroom etiquette.
I would just disagree on the headphones. I do believe is not courtroom etiquette, but the trials that I've been in that lasted a long time, judges don't mind the defendants. Just from what I've personally seen, they've never had a defendant eating, as long as it's not something like a sandwich or something, chips making noise. But they've never really, other than that, the trials lasting a long time. They've never had. I mean, I'm just saying from what
I done been on 2 trials. They don't even let you chew gum in them courtrooms.
You cannot eat in the courtroom, in federal court, and most states.
No courtroom. I done been on 2 trials. They don't even let you chew gum.
I mean, but I think that's just a minor thing, guys. That's just one of the changes because it's her rules.
No, it's courtroom etiquette. She just setting the tone. She getting the shit proper.
But I think one of the biggest things was how she's going to streamline this trial now. It's no more petty witnesses, no more evidence.
No more. Yeah, that's gonna be big. The evidence at the last minute.
Be big because that's a big part of the state's case was allowing all of this inadmissible evidence that was being omitted, and that's going to stop.
And even the whole part about the witnesses and like what indictments they're speaking to and what they're gonna say, that's gonna be big too.
Yeah, you got them up there just yapping away about nothing.
I mean, granted, I don't think they have much of like witnesses left after Woody, but still.
What Shelly is doing down there? Like, what you got going on?
I'm agreeing.
on
Oh,
mute.
Wait. Who blocked me from the chat though?
oh, it don't matter. Nobody, it doesn't care. That's irrelevant.
I was just
Hey, yeah, listen. Let's stay focused.
Right.
We're going all over the place. People already want the reading to be done, guys.
I mean, I gave a cliff note of the motion.
Miss
I know.
Sylvia, Miss Sylvia.
Hold on. I did not plan on reading the motion tonight because we were discussing stuff that happened in the courtroom. Now, my reader, now if she's willing to read and I'm not too tired, I'll do it. But we weren't doing the reading tonight. We were not. We were gonna do it tomorrow. All right, go ahead. Somebody was saying something?
I just got one question. So I tried to do the super chat. Am I doing it wrong? Because when I try to make a comment, I can't make the comment on the super chat for some reason.
I don't know. Maybe something's going on with YouTube. I've been hearing so many craziness with YouTube lately.
Okay.
I don't know.
Hey, Miss Sylvia.
Hey, Q.
I just wanted to chime in and thank you for everything that you've been doing. As I looked at it today, I've been following the trial for quite some time too. What I can say from Judge Whitaker, I really do think that she will be good. I think she's gonna follow the law as best, even though she has been a prosecutor before. I really do think that she's gonna go about the law. And as far as the state goes, they just gonna have to come with their A game. The first mistake that they make, I feel like she's gonna nail them to the cross, and that's gonna be it. And the case will be dismissed, or it'll be over. And that's about all I have to say on that.
I don't think that she'll do that. I don't think she's looking for like the state to like mess up on the first opportunity. I think she's expecting all of them to act professional and to, hold to the standard of being a lawyer and present their case the best way that they're supposed to. Now, if they continue to do the same thing, I think that she will, do what she needs to do. But I don't think she's looking for like the first opportunity window to do that. Because if that's the case, I think she probably could have found it in motions that were already probably, filed. So I think that's fair. But I do agree that she don't want to be up in there and she don't want this case. But she's going to do her job.
Nah, I mean, I don't think I agree though. I don't think she's looking for like the first opportunity, but I kind of found it interesting how she said repeatedly during her hearing today that if we continue, she kept saying if we continue, like as if it might not continue.
Yeah.
Yeah, but don't they have a motion for mistrial? Didn't somebody submit a motion for mistrial? Or a couple of them.
They filed that after though.
Everybody has.
Yeah, so I mean, so the motion for mistrial has to be ruled on, right? And then, Ms. Silva, here's a question I have for you. If let's say they file a motion for mistrial, and let's say she denies it, can they do an interlocutory appeal and have a case stay until the motion is heard, or no? They have to wait till the end of it.
You have to ask somebody that knows law. Like, okay, I don't know law, and I'm not going to sit here and try to act like I know law.
I just was curious. Okay.
I can give you my opinion, but my opinion is not worth a hill of beans.
It is. It's worth a lot of beans.
I think,
yeah, they can do it. If you're gonna ask me that question, yes, they can do it. But are they going to? That would cause the case to still.
Like someone in the chat just said, I think Judge Whitaker basically put the state on notice today that she's aware of all the BS that they've been doing.
But
for shit show.
Judge Whitaker also stated the motions that she still needed to review. She said the one for the bond, and then she said one of Weinstein or one of what's his name, Steele's, and it was not a dismissal motion. So she's only, if that's a motion that they want, I think that they're going to have to redo that motion because she stated the motions that she currently had on her desk that she had to rule on. And any other motions, which none of those motions she mentioned had to do with, dismissing the case that she named. They would have to file something else to state that, in my opinion, from what I understood, what I heard.
I mean, but Sylvia, does it have to be a motion to dismiss this case, or can the judge, like in the other trial, just do it based off of?
It has to be a motion submit. They can't just do it. They have to find they have to put a motion, and they have to put what reason, the cause, and everything, and then the state has to argue, and then they have to make a decision based on what's put down. If it's something that's constitutional violation, that would be a strong argument for them to go ahead and.
Well, I was just going to say that's in the bad, because the other guy already has violated their constitutional rights.
I mean, I agree, because I feel like she said when Steele went up to speak the record, I guess is the best word that I could say, and to tell her whatever he wanted her to know. She said, "Did you have a written motion?" I think she's not ruling on nothing that's not a written motion. She's only gonna going off of written motions. If you didn't write it, then write it. If you verbally did it, she ain't here for it. She wants.
But she's also, she said she would listen to those. She said she would listen to those as constitutional violations too. So even if it was something in the past that they did and nobody really addressed it, but if it's something that's diehard constitutional violation, she will look at those.
I'll tell you one thing though, Steele filed that motion right after.
Oh yeah, that's all he been doing.
Secondly, though, if they filed a motion to recuse the judge, right, and that happened, why wouldn't the same thing happen for the prosecutors? How could the judge not stay on the case, but the prosecutors could? Isn't he more at a higher level?
Yeah.
Miss Sylvia,
Are the standards the same or different? I mean, I guess I didn't see Steele's motion, but what are the standards for having a prosecutor removed? I would think the standards would be a little bit different.
I think the standard would be higher for him. That's why I'm asking. My question is, how could he be recused and the prosecutors not?
Because you know what? We will see the answer once this is get done.
we touched on that yesterday, Miss Sylvia.
Right, and he's already filed that motion to recuse both of them.
Oh, he did file a motion to do that?
Didn't he?
Yes, it is in.
Yeah, I was gonna get those motions.
But we're not going to put them out there because she still has yet to cover it. So I think she was just waiting on that. Miss Sylvia, I just need to just chime in for 1 second just to tell y'all bye. Appreciate the time. I do have to run. I have a 20-minute consult. So you all take care and have a blessed day.
And I'll call you.
I'm
about to get off of here.
Hopefully for real today.
I'll call you.
All right. Y'all have a blessed one.
All right.
You too.
Listen, guys. Okay, Renee's coming up. She's gonna explain some stuff to you because she's the guru of the law. Renee, go ahead.
Oh, okay. Can you hear me?
Yes, I can hear you.
Okay. I was just listening. I'm on my way to an appointment myself, so I was like, I'm gonna just get on the car. I don't know. I didn't catch anyone's questions. A lot of times when I'm listening, I'm missing my thoughts too. So, did you recall anything anyone said or asked?
Okay. Maya, you want to ask your question again because Renee is here.
Hey, Renee, how are you?
I'm good.
My question is that, so like when Steele and them file an appeal for a mistrial, if the judge denies...
Oh, that's what okay, all right, that's one thing, okay, because I was having this conversation. Well, I would say my response to that would be, because you have to look in the order to which the motions were filed. If I recall correctly, Kendrick's lawyer filed the first motion to recuse. And he just filed a motion to recuse Judge Glanville. He didn't say anything about anybody else necessarily, even though the facts did entail them. He honed in on Glanville, so that's what they ruled on. Because the judge wasn't ruling on anything, she was kind of having like a meeting of the minds to get a feel of where everyone is and where the case is. That's why she wouldn't rule upon back. Those motions, I think the 30th is going to be a heavy hitting day for everybody. So if that answers your question, it's
We're about to discuss
the
everything.
motion,
That didn't answer the question. So
the
let
order.
me rephrase it. If not the order, but what I'm saying is that for the motion for mistrial, if she denies it, can they file an interlocutory appeal on just that motion alone?
Oh, I'm sure she's going to give them that. She's going to give them that. Absolutely. Because a lot of how she kept saying constitutional rights, those are issues that get convictions overturned on appeal because of those constitutional violations. So I think that, nobody wants to be told they're wrong. So they'll often won't let it in because that's something that could be brought up on an appeal, an evidentiary issue. And that's why she's saying constitutional rights. When you violate somebody's constitutional rights, that's what typically gets you popped on appeal.
And she was speaking directly to the state when she was saying all that.
Did y'all catch how she asked Love to get the list and then she was like, nah, I get it myself.
Facts.
Yeah,
She was like, what she
I
said?
think she
The
set her up for the deal
the transcripts will be correct. That Miss Love wasn't about to be correct.
She was like,
but
nah,
the judge turned around and asked her, so do you have the list? She said no. But blowing smoke. Why you blowing smoke?
Yeah, man, Love, all them lies Love was telling ain't gonna work.
I do.
Listen, good people. I have not eaten at all today, and guys, you remember I am a diabetic, so I got to get off. I'm starting feeling sick right now, so I have to get off for a minute.
Go get your sugar up.
Yeah, I got to.
Yes, go take care of yourself. Totally understand.
Thank you, per usual.
All right, guys. Sorry about that, but when I get myself back together, I'll come back and I'll have.
I'm gonna put in a motion so you can have your snacks, okay?
I'll have Liz to come in and we'll read the motion, but I gotta eat some. I'm starting to feel weird. All right.
Yeah.
All right. See you guys later. Bye.
I'll read that.
Bye, guys.